Zamuto, the President of the Osteopathic Medical Board of California. I'd like to welcome you here. Before we officially start the meeting, I'd like to remind everyone, as a courtesy, I just lowered the volume on my ringer, or put it on mute, so that, and I remind everyone, if you have to take an important phone call, please do so in the hallway as to not to disturb the meeting. This is being webcasted today, so make sure you look your very best on camera, if you happen to be on camera. If you see me playing with my collar today, it's because I forgot my stays and it curls up on me, so hopefully that can be edited out. The chair declares that it's 10 o'clock, and it's I'd like to welcome everyone to the Thursday, September 27th, 2018 meeting of the Osteopathic Medical Board of California. We are located at the Department of Consumer Affairs, Headquarters Building 2, parentheses HQ2, close parentheses, 1747 North Market Boulevard, Hearing Room in Sacramento, California. For those who are watching the webcast, thank you for joining us. So, first order of business then will require a roll call. Pacheco, are you ready to proceed?
Yeah, Dr. Zuhari.
Present.
Andrew Marino.
Present.
Dr. Jensen. Present. Claudia Mercado.
Present.
Cheryl Williams.
Present.
Dr. Zamuto.
Present. Thank you. I need to make a couple of announcements. People have been asking me about Dr. Lally's sitting away from us. For those of you that don't know, Dr. Lally currently has a new position. He is our independent consultant, taking the position of Dr. Donald Kirpin, who, as you all know, left us last year. So as a result of it, because DCA policy, Dr. Lally had to resign his position as a board member so as not to have a conflict of interest between being a board member and our consultant. So I want to welcome Dr. Lally in his new position, and congratulations to you. One of the things that Jim and I were talking about today is, in the future, for greater transparency, he'll be giving a presentation in the meetings, in future meetings. So we're trying to do it even better. Okay. Next, I would like to ask for any public comment for items not on the agenda. Okay. Next, review and approval of board minutes. We'll take them separately. First, May 17th, 2018. Is there any correction to the board minutes? Any additions or deletions? Next, I'll ask about July 10th, 2018 board minutes. Any questions, deletions, additions? Hearing none on both of these, I'd like to next ask for a vote of acceptance of these two board meetings. Remind me, is this a... Okay, motion please.
I motion to approve the minutes.
Is there a second?
Seconded.
And this requires roll call. Machiko, please lead the roll call. Yes.
Dr. Zuhari.
Yes.
Andrew Marino.
Yes.
Dr. Jensen.
Yes.
Claudia Mercado.
Yes.
Cheryl Williams.
Yes.
Thank you so much. Next is President's Report. And what I'd like to talk about is I attended the annual meeting of the American Association of Osteopathic Examiners July 19th, 2018, at the Chicago Marriott Magnificent Mile Addison Room, 4th floor. And at this meeting, we have all the other osteopathic licensing boards represented, and there are 16 individual boards. For those of you not familiar with the makeup of boards, in some states there's composite boards composed of MDDOs, and in 16 of our states we have individual boards like we do here in California. And this is an opportunity to talk about national policy and concerns. We had representation at this meeting from the Federation of State Medical Boards, Dr. Hank Chaudhry, who is the CEO and president. The Federation is composed of 70 boards, and the way we get 70 is we have 50 states plus 16 osteopathic states plus 4 territories: Guam, Virgin Islands, Marianas Islands, and one more. I can't remember right offhand. We also had a presentation from the National Board of Osteopathic Medical Examiners updating the status of testing for medical students, for the predominant amount of their work throughout the United States, and the fact that they will be continuing to function even as the amalgamation under ACGME for postgraduate medical education. They also provide exams for physician reentry if they've left practice for a number of years for whatever reason and they wanted to come back to practice. They can undergo reevaluation testing. Next, we had a legislative update from the AOA. Their attorney, Rain Richards. Apparently, there's been some issues with an organization out of Canada who have been creating an osteopathic education, and they offer it an online program to certify people who can call themselves trained in osteopathic medicine. However, this organization is not duly sanctioned in the United States, and we've actually had questions from people who want to know, can they apply for an osteopathic license in the state of California, and the answer is no. So there are some unusual things happening. Our duty, as you know, is to protect the public, and this is not only a state concern but a national concern regarding misrepresentation of people's positions, and it goes back to confusing the public in terms of verbiage, in terms of what people call themselves. Unfortunately, we do not have authority of these people because they're not under our jurisdiction, and this becomes a issue that the American Osteopathic Association and their legal department has been looking in, and there'll be updates on that coming up. Also, an important discussion regards preventing physician burnout and safe haven protection for physicians. With us today is Kathleen Creason. Kathleen, as you know, had been the executive director of the Osteopathic Physicians and Surgeons of California up until the middle of this month. And now she has a new title as executive director of a new service, which is called Physician Wellness Service, under the California Medical Association, with a joint project with Stanford University. We applaud Kathleen's decision to move on to a much larger position and a bigger movement to make a difference in the healthcare of not only physicians, but also medical students, residents, and interns. There is a problem with burnout at each of these stages, as well of risk of substance abuse and suicide risk. And what the House of Medicine has realized is we need to be very proactive and reactive as well to help our people succeed and not fail. And later in the meeting, I'll ask Kathleen to address something that's on the agenda. There was some discussion at the meeting about postgraduate training licenses, which was interesting because that's something that has come to our process due to Senate Bill 798, which is Mr. Jerry Hill's bill. And there are states who do have postgraduate training licenses and new license requirements that has been presented to us. We do have the Federation of State Medical Boards, which is a resource for us so that as we work with this process and discuss this with the legislature, that we have the best up-to-date knowledge so that we can be positioned for this. More to come regarding that. Are there any questions I can answer regarding these topics of interest?
I have a question. Just out of curiosity, when you were at the conference in Chicago, were you aware of any other states that were willing to accept those individuals who studied at the online school in Canada? I'm just curious what the other states' comments were on that.
All of the other states represented there were in the same position we are, that we felt that this was a educational institution which can grant whatever degree or certificate that the law of Canada allows them to, but they do not meet the requirements nationally, which is federal, educational guidelines to allow them licensure in their state. There are specific institutional requirements that each of the medical colleges and osteopathic colleges have to fulfill federally and statewide to be granted authority to do what they do. And this organization out of Canada does not have any jurisdiction. Any other questions?
So if they, just like we have people that are educated overseas and they come here for nursing, will there be a test maybe down the line that they can take to see if they meet the qualifications? And I think that's what maybe.
Somewhere along the line.
Yeah.
At this point, we don't anticipate it because they do not fulfill the requirements which are constructed to verify and validate people who are eligible for testing. Any other questions? Okay, thank you. At this point, I would like to invite Mark Ito from DCA's Budget Office to give it a budgetary update, and he has a handout that the board should have received. And will this be available for the webcast people for viewing? It is. Okay, it'll be added. Okay. You want to check your mic and take it away?
Yeah, awesome, thank you. Good morning, everyone. Good morning, board president, board members, legal counsel, Dr. Lawley, executive officer. My name is Mark Ito. I'm your budget manager from the Department of Consumer Affairs. I'm excited to be here today to present your budget, answer any questions you have, and alleviate any concerns you may have regarding your budget. In front of you, you have a couple documents. You have expenditure projections from fiscal year 2017-18 for the prior year, and you have a fund condition in front of you as well. The first document is the expenditure projections. This document shows your actual expenditures from 2016-17, and it shows expenditures from 17-18 through June 30th of 2018, based on our preliminary month 12 report that we received out of Fiscal. So with that said, the way this document works here for 16-17, if we move from left to right, the first column shows all the different line items where your expenditures come from. The next column, if we move over to the right, for 16-17 shows your actual expenditures for last year, and then the column to the right of that shows your expenditures at this time last year. So for this expenditure projection, those two columns are going to be exactly the same, because that's where you ended off last year. Now for 17-18, the column to the right that's titled budget allotment, that shows where your dollars are appropriated per line item. And then bottom line, you guys have $2.353 million was your budget for last year. Your current year expenditures, your expenditures through June 30th, 2018 are the next column. And if you move to the right, it'll show my projections for where you guys are projected to end up at the end of 17-18. We haven't closed 17-18, so it's still open at this point. But I'm showing that your reversion will be about $216,000. And those totals do include a couple of things. They include the $75,000 we put aside in the architectural revolving fund to assist in renovating your suite this fiscal year. So that is included in your expenditures, and it includes all your enforcement and your salary and general expenses in there as well. So you are going to have savings in 17-18. Like I said, we haven't closed last year. It is taking longer than normal to close the fiscal year. We're working hard to do that. One of the main issues with it taking longer is that we're not all on the same financial systems. For State Controller's Office isn't on Fiscal yet. We are, so it's not apples to apples when we're working, figuring out how to close the system. So we're working hard to do that. But you can be rest assured that the budget office is keeping track of your expenditures and making sure that you don't blow your budget. So with that said, if you have any questions on your expenditures, I can answer those now. Otherwise, I'll move on to your fund condition.
Why don't you go ahead, and then we'll
Okay.
save questions for the end.
Thank you, Doctor. So the next form is your fund condition. This shows the status of your fund. It shows what your beginning balance was for 17-18, and it shows 18-19 through 2021. It shows what your beginning balance is for those fiscal years. Now, the way this document works, if you go from top to bottom, is the beginning balance is the top section there. That is your balance at the start of every fiscal year. The next section is your revenues and transfers. For 17-18, those are your actual revenue dollars based on the preliminary month 12 report that we received out of Fiscal. And for 18-19 through 2021, those are based on projections that the board provides the budget office. And we're actually working on that as we speak. So this fund condition should be updated within the next month or two. And then moving down, your expenditures for 17-18, those are your actual expenditures for 17-18. No, that expenditure total includes your reimbursements, which the majority of reimbursements for most programs are for cost recovery or for fingerprint reimbursements. So the way expenditures work in the fund condition for actuals, we look at your actual expenditures, and then any reimbursements you bring in for cost recovery, et cetera, they offset expenditures. So that's why you see the 2.086 down there. And as you move forward for 18-19 through 2021, those expenditures, that's your full appropriation. We anticipate in a fund condition as if you're going to spend your full entire appropriation. 99.9% of boards do not do that. So you will have, your expenditures will be less than that when the actuals come out for this fiscal year at the end of the year. And then the next column is your fund balance. So to kind of easy way to look at the fund balance is the fund balance is your beginning balance plus your revenue minus your expenditures. And that's what your fund is anticipated to be after every one of those fiscal years. And then the next section is the Munson Reserve. Now the Munson in Reserve, kind of an easy way to look at that as well is to, if your board did not bring in any more revenue starting at the beginning of the fiscal year, that's how many months that your board can sustain its operations prior to becoming insolvent. So with that said, a couple other things on here. In 1920, we're anticipating that you'll get your general fund loan repayment back of $1.5 million.
2020?
2019-20, so that's next fiscal year.
Oh, 19?
Mhm.
Oh,
Yeah.
somewhere.
Yeah,
Okay.
and we reassess that every year, so it could move forward, could move back based on your board's need for the general fund loan repayment. So
And that'll be in installments or would be
it'll
one?
be a lump sum. So with that said, your program is working in a slight structural imbalance, meaning you are spending more than you're bringing in. So if you look at the Munson reserves from 17-18 to 18-19, you're going down about 2 months. However, you're anticipated to get that general fund loan repayment in 19-20, which will bump the Munson reserve back up to we're anticipating to be about 15.1. So at some point here, you'll have to look into increasing fees to make your program structurally balanced, where you bring in the same revenue as your expenditures. And we're planning to work with Angie and the board to ensure that you guys do that.
Yeah, I was thinking about from 2020 forward with the training license that there's a difference, at least at this point, conjecturally, that the training license will be a certain fee and the full license will be a certain fee. And then to understand what the revenue surplus or revenue shortfall would be depending on the prices of the licenses and if they're different. And part of it too is because our state continues to grow, we have another osteopathic medical college that's in process right now. I met the dean earlier this month, and we don't know for sure. There's supposed to be a fourth school coming out, so we don't really know what the influx of osteopathic licenses will be relative to in-state education yet. And we don't know yet what the influx of out-of-state license requests are going to be. There's still a lot of particulars before 2020 that have to be determined what to do about people in training who come into California who have a full license and how to handle that. And that's a legislative discussion that's going on, but that does have a fiscal impact.
Absolutely.
In terms of what's happening 2020 and beyond. So it'll be interesting to kind of prepare for that. I'm not quite sure the financial answer to that. I guess as we get more data back from legislature in terms of any modifications to the Senate bill, we can see how the fiscal impact is adjusted, and then hopefully be well prepared. And the fact that we may get our loan money back will at least help us in that time. It'll be good timing.
Absolutely.
Any questions from other board members from what we've heard so far?
I have a question. Hi, Mark. I think you've mentioned before, but I need reminding. When we're looking at the fund condition and specifically Munson Reserve, what's generally, and if you can even tell me, a safe number where a board should be operating in, or does it case by case specific per each board? I mean, for us, what's that number for Munson Reserve that we should just be kind of on the lookout for?
I think it's case by case. I think it depends on, you can look at what your structural imbalance is. If your Munson Reserve are going down pretty dramatically, you're gonna wanna address that pretty soon. But I think you guys are okay. I think, like you're going down a couple months, it looks like, every fiscal year. So I think somewhere between 6 and 12 months is pretty comfortable for you guys. You do have that general fund loan repayment, and I believe I've spoken with Angie. I think you guys are going to look into doing a fee increase here pretty soon, or at least starting the process at this point. But I think you guys are comfortable. There is also statute that says you can't be over 24 months without having to look into reducing your fees. So I think for you guys, since you're going down a couple months every fiscal year, I think somewhere between 6 and 12 is pretty comfortable for you guys.
What would be the, excuse me, what would be the marker to tell us that we should have fee increases, and by what percent should we make those increases?
That is something where Angie could work with the budget office. We can help determine that. If it's something that's going to be a board-wide kind of, we're going to look at the entire board, all of your fees. That's something you may want to look into doing a fee audit to get an independent vendor out to kind of look at your program, figure out how much all your processes cost, and then determine what your fees should be. So there's a couple options of looking at it. In terms of time frame, it all depends on if you can increase your fees through regulations, or if you have to go get legislation to increase the fee levels as well. Because typically programs have statutory language that states that your fee, that there's usually levels, there's a minimum and maximum kind of what your fees can be for every fee type. So it all depends. If you're kind of in the middle of where you're allowed to charge and you can increase your fees through regulation, then you just have to do a regulation package. However, if you're already at the maximum amount that you can charge, then you have to get legislation in order to increase the statute.
And what's the time frame for that? How much time of leadway should we give ourselves?
For regulation,
Yes, just in case we have to go there.
I'd have to get back to you on that to kind of figure out exactly how long the regulatory process is taking for fees right now.
Anything else for us, Mark?
That's it.
It was very, very good, and the information is very helpful for us. Is there an anticipation of a time whereby we'll have regular, up-to-date reports?
Yeah, we're trying to gather information on when an actual report's going to come out for 18-19. However, in the meantime, we are working. What we can do is the fiscal system is transacting properly in the back end, so all the transactions are going through. So we're able to get what's called an extract out of the system, kind of an activity report of what's actually happened in the system. So we're working with accounting to get a activity report, and through that we can do projections for you in lieu of getting the reports. So you won't be getting your actual reports in, but you won't be completely in the dark of where you are expenditure-wise.
Right, because that'll affect how we set up budgets and things like that.
Absolutely, absolutely. It's something we're very interested in as well.
Okay, thank you.
Yeah.
Very good. Thank you very much for
Awesome. Thank you,
a
Doctor.
good presentation.
Board members.
Appreciate it. Okay, our next item on the agenda is Executive Director's Report, Angie Burton. Want to get a mic? Do you want a portable one instead?
I think, can you hear me? Okay. Okay, so this board is provided to the board members with an update on licensing stats, staffing issues, cures, and enforcement functions at the Osteopathic Medical Board. So I did a fiscal year number counts this year. So at the end of fiscal year, which was June 30th of 2018, the OMBC license count was active licensees 8,868, inactive licenses 573, which totaled 9,441. And additionally, there's still 1,070 licenses in a delinquent status, which are still within our jurisdiction. So the total licenses within our jurisdiction is 10,511. And in-state licensees actively practicing here in California, we have 7,696 DOs. And we have 52 with inactive status who are currently residing in the state of California. The number of applications we received in fiscal year 17-18 was 873, and the number of licenses issued was 891. Fictitious name permit counts at the end of the fiscal year was 728. The number of fictitious name permit applications received was 142, and the number of fictitious name permits issued was 118. And the number of days to approve a license application during the fiscal year of 17-18 was 44 days. Applications with missing documents took an average of 102 days to complete for approval. Okay, any questions on the stats?
Just a quick one.
Mhm.
For the applications received, it's 873, and then the licenses issued is 891.
Mhm.
Where does the difference come from?
Some of the applications may have been received in the prior fiscal year, but completed within this fiscal year.
Okay, thank you.
Okay, the postgraduate training license we spoke about a little bit earlier. As you're aware, SB 798 created a new license status, the postgraduate training license. The new law will require all physicians, both DOs and MDs, to complete 36 months of residency before they will be eligible to apply for a full, unrestricted license to practice medicine in California. The current law requires physicians to complete their first year of postgraduate training and apply for and receive a full, unrestricted license before commencing their third year of residency. This new 3-year requirement law will become effective on January 1st of 2020. And the staff is currently working with the Breeze team to make necessary changes to the database to be able to accommodate this new license status. Staff attended the Breeze Change Control Board meeting on September the 10th and explained to the board the various changes needed in Breeze. Our liaison with the Breeze team has been extremely supportive and is working very closely with the staff to make this process as efficient and smooth as possible. Staff is also working on all new application forms needed to implement these upcoming changes. And Ms. Thorfinson will have more details on this process during her report. We will also be updating our website to add informational articles about the change, and we will be conducting some educational outreach. Do we have any questions on the SB 798?
What kind of educational outreach do you think is necessary?
Well, we will be, as a matter of fact, we'll be going to Kaiser and speaking with their staff there and giving the residents information on how to apply, and at the same time, we'll be telling them about the changes that are upcoming.
Is Kaiser the hospital or the entity that has the most residents?
Not necessarily, but they're the ones that first reached out to us, so we're going to start with them.
Being proactive.
Yes.
Yeah. That's good.
So moving on to staffing. After a careful extended search, the board selection committee chose our medical consultant, Dr. James Lally, DO. He was hired as our new in-house medical consultant. Due to a conflict, which we've already mentioned, Dr. Lally had to resign his position as board member. I have been in contact with the governor's office requesting appointments to replace our 2 professional positions, one vacated by Dr. Feinstein over 2 years ago, and a more recent vacancy created by Dr. Lally leaving the board to take this medical consultant position. And I've also been in contact with the Office of the Assembly Speaker of the House asking for an appointment to fill the vacancy created by the departure of Ms. Megan Lynn Blair. To date, we have not received any response back from either. But I do know that there are quite a few applications at the board, at the governor's office for the 2 professional positions. So we're hoping to get an appointment in the very near future. Okay. And our enforcement analyst, one of our enforcement analysts retired on June 1st. We announced our vacancy on the CalCareer site. This is a site where all available state jobs are listed. We received over 150 applications for this one position, and after carefully reviewing every application, we selected the candidates with the most experience in enforcement and interviewed several excellent candidates. After narrowing our search to the 3 top candidates who were asked to return for a second interview, we made our final selection. And I'm happy to report that Robin Matson was selected. She comes to the Osteopathic Medical Board from the California Board of Registered Nurses Enforcement Unit, and her first day at the Osteopathic Medical Board was September the 17th. And she is working out really well. And then on September the 13th, I notified the board members via letter that I will be retiring from state services after 31 and a half years. My last day with the Osteopathic Medical Board will be December the 29th. I thank each and every one of you board members from the bottom of my heart for giving me this wonderful opportunity to serve the OMBC and the consumers of this great state. It has been a pleasure working for you, and I assure you that with the current core of staff at the Osteopathic Medical Board, it will assist in making the transition for the new executive director will be smooth. And we have Nicole Lee from DCA HR, who will be providing us some assistance in this recruitment process.
Welcome, Nicole.
Well, good morning. Thank you for having me here. And congratulations, Angie,
Thank you.
on your upcoming retirement. So I'm here to talk about the process for executive officer recruitment. You probably have received a flow chart that looking like this. It's just a quick overview of what we do during the process. We work very closely with the selection committee from the board. I do believe that in the near future, there will be a telephone conference meeting for the board to review the duty statement. Our office has been working very closely with Angie, and we updated the duty statement, so we do have a copy of the revised duty statement. We're also going to draft what we call the recruitment announcement. The purpose of the recruitment announcement is to identify the desired qualification that you would like the new executive officer to possess. So I will be sending it out to all board members in advance of the next telephone conference. That'll give you time to review both documents. And at the conference, we can just quickly go through. If you have any comment, edit, review, and we gain your approval at the end of the telephone conference meeting. With that, then we will be able to post this job. The board president can independently appoint 2 members to designate at the selection committee, or the board president can allow the full board to make that decision altogether. It works both ways. I'm just here to provide the support. The reason we're asking for only 2 members on the selection committee, because I will have weekly communication with the members. And if I would have to communicate more than 2 members, then every time we'll have to call for a board meeting. So that's the reason why we'll ask that you possibly just appoint 2 members. We'll move to the job posting. So we have this website that we are required to post all state jobs. It's called the Cal Career, and it's managed by the California Department of Human Resources. They are referred to as Cal HR. That's a job site that we are post all of our jobs on, but we can certainly coordinate with the board to post additional advertisement on the Capitol Morning Report. We can also send the job advertisement through a social media site, Facebook, Twitter, a front page of the internet, the same the board can do. Also, this can go through listserv as well. Our office will collect all applications that coming in, and every week, again, I will update the selection committee. There will be conversation about the update, the application received, any assistance that they need us to help with. Members of the selection committee should have very well-rounded understanding of the board, including any issues and challenges that you foresee in the future, because the purpose of having the selection committee is require a lot of discussion between the 2 of us to help design interview questions. The selection committee will design interview questions that would be able to bring out the best candidates during our selection process. Depending on the number of applications we receive, the selection committee might do preliminary interviews to narrow down the candidate pool. Typically, they narrow down to maybe 3 finalists to be brought in front of the full board, so the board have an opportunity to meet and interview the finalists. However, all applications will be made available for board members to review at that time. Once the final interview is conducted and the board make the decision on the final candidate, then our office would assist with making conditional job offer. The reason it is a conditional job offer because the executive officer position will require to get fingerprint. That's part of the requirement for this job. And also at the executive officer of the board, he or she will have to be sworn in before they can take duties of the office. So by that time, we'll sum up the recruitment process and you'll have a new executive officer. Based on the timelines that we have with Angie upcoming pending retirement, I think we should be able to have a person on board on January 2nd.
And that is completely, the process is complete, they're sworn and they're ready to take charge of the office?
Of course, it's all about the board members' availability for that final board meeting to do interview. But timelines-wise, because I'm looking at the next meeting, possibly schedule, given 10 days notice, possibly schedule in the next 3 weeks. Job posting can go live for 30 days. So we're hitting timeline relatively close, but not where it become uncomfortable. Like, we're not gonna be able to make it. So the final board interview can happen sometime in December. And if that happens, fingerprint doesn't take very long. I have seen results taken within 24 hours, but on average it's 2 days. And swearing in, that can be done by the board president or one of the board members, whomever closer to the Sacramento area can do this ceremony. And it can, yes, and it can also be done by the directors of DCA.
Any further questions?
Just a point of clarification, the selection committee is going to nominate their prospective applicants, but it's the full board that makes the decision, right?
That is correct. So for example, if you ended up with 7 applicants, it's a very time-consuming process for the entire board to see all 7 on a board meeting. So we'll recommend that you bring it down to maybe 3 finalists only, but all board members will have an opportunity on that day to review all 7 applications.
And vote, I'm assuming. I mean,
On
the
the
decision.
finalists.
Right,
Yes,
okay.
yes,
And-
because it's required board decision.
Right. And then just in case, for whatever reason, we go beyond the end of December, what's the process if we haven't selected somebody by that point?
Yes. Keep up. So, I know we have options. I know Angie did mention earlier that she willing to extend if it's necessary for her to extend her retirement. The board also have the option to appoint an interim or an acting executive officer. Let me go quickly to describe the difference between the two, interim versus acting. They both have the same authority. They're both gonna do the exact same duties. However, an interim candidate require a full board vote. So the board will have to take action to vote an interim in. The interim candidate will get that compensation, whatever the compensation will be appropriate for a person who in the executive officer position. The acting executive officer can be appointed by the board president, and it has to be an existing board employee. And the person will not receive additional compensation as the executive officer. The person will retain his or her current salary.
So would be more advantageous for Angie to stick around until we hire someone. Her position.
I don't know, that's a question more for Angie.
That's a good presentation. So I'm very serious about being involved in this process. I've been involved with previous selection of people for different roles. So I'm going to be the first worker bee that's going to bring candidates to the board. And what I'd like to do is, if there's anyone seated amongst me who can make a commitment today, I would welcome that. And if you can't make a commitment and you need to think about it, we can make it later. I don't want to put anybody on the spot. But we need to come up with a worker committee so that we can get things rolling. And I'll just ask, is there anybody out there who's excited about this opportunity to?
I'm excited, I just have to make sure I can commit to it in terms of time frame. You said
Okay.
there's, on a weekly basis, just monthly basis, how many hours are we looking in terms of making sure that we're successful and efficient?
Yes, so typically, we'll post for 30 days to allow people to prepare their application package. That's the reason why the 30 days is out there. The first, second week, you might not get any applications. It's the time that applicant will spend to polish their package before they send it in. You might start seeing application on the third week. Most of application, based on my experience, come in the last week. So they can come in multiple applications. It would require your time to review each and every application, talk with each other to see what's important for the board, what you need to look for, and although everybody explained their qualifications, you have to pick and choose who's better suited for the board based on their experience and qualification and education that they outline on their application package. That's the process that might require a lot of your time and devotion to.
Can
Further,
I ask
you-
a quick question?
Yes.
Is there an initial screening that HR does to verify that it's a appropriate, full, complete application and it's valid, so that we're not looking at an application that's incomplete or an application that's falls outside the.
So
What I'm
that's
saying is, if you
I-
have 100 applications come in, you know, we want to get the ones that are complete and ready to roll.
one, you won't get 100 applications.
I just use that because
No,
I don't
no,
want to look at
understand.
100.
I understand. Typically, I would be extremely happy if these recruitment you about 10 to 15 applications for you to review. Our office can provide assistance, but we do not take the lead in eliminating these applications for you. However, when I send you the application, I might give you a little bit assessment. Like, for example, the person said, I sent in my resume, but the package does not contain a resume. I would let you know that.
Yeah, because what I'm saying is, I would like this working committee to have a complete package. I don't want to have incomplete packages and waste time.
But I think that's up to us. If they're.
Well, I mean, what
I
I'm
would
saying
alert
is
you
just,
with the information.
Yeah.
And you can use that in any way the selection committee feel comfortable with.
okay,
Does that help?
Yeah.
Yes. Again, you won't get, based on my experience, this type of position is high level. You will not get a lot of applications.
okay,
Again, I'll be happy if we have about 10 to 15. Usually, that's a really good number that we receive. Some of them might receive very low numbers, such as 5 or 6. So usually, again, go back the third and fourth weeks. That's when you review a lot of application. That's when the two selection committee will be talking about interview questions. What should we ask them? What are issues that we want to be able to address or get the insight from candidates through these questions? although I can certainly provide you with sample questions, I strongly encourage you to use that as the base and kind of expand it to make it work for your
Right.
board.
We also want to know the questions we should not ask. So,
Absolutely.
you know, we want to make sure we're doing
Yes.
everything by
Yes.
the rules and regulations. So
Yes.
hopefully legal will say these are all fine questions to ask.
Usually our office would take that role.
Okay.
Because we've been dealing with interview employment questions. So that's why we design sample questions for you. And I'll be more than happy to review any questions that selection committees would come up with.
Great. Any other questions?
For clarification, after the selection committee is set, a lot of this can be done telephonically, is that right? So you can send them the application either electronically or paper, whichever they choose, but this conference with you can be done telephonically.
Absolutely. I'll make myself available. Usually we set up a conference call in between the time to have discussion. When I give you application through a weekly update, it's usually by email. I don't send you hard copy. That way, even if I receive hard copy, they're gonna be uploaded into my email before I send it out. So it doesn't require anybody having to physically travel to any particular location. Our communication was strictly email or by telephone.
All right. And what I will do personally later today is I'll send you my contact information.
Yes, thank you.
Thank you so much for being here, and we look forward to working with you and have a successful successor.
A big shoe to fill. But thank you so much.
Okay, take
Thank
care.
you, Nicole.
What I wanted to do before we go to cures, I wanted to go out of order. Kathleen Creason has a brief discussion, and she's on a timeline and needs to get to another meeting in the middle of the city. So I'd like to go to item number 9, discussion regarding mental health questionnaire on OMBC initial application. Kathleen, can you come to a microphone, please?
Thank you very much for accommodating my schedule. I very much appreciate it. As Dr. Zumuto mentioned, there is an item on the agenda, and it's in relationship to questions that are asked of potential licensees on the license application form. And coincidentally, Dr. Zumuto had brought to my attention yesterday several publications by the Federation of State Medical Boards on this specific topic. And in their documentation, they had a recommendation on the specific language to use if a question is to be asked about mental health. So I shared that with Angie, and Angie, I think that you said that you had hard copies that you
I did.
brought.
I handed it out this morning.
Okay.
Yes, thank you.
Excellent. So I am speaking in my new role as CEO of the Physician Wellness Institute. And in the short period I've been there, I've been able to do a lot of reading on the issue of physician wellness and physician burnout. And one of the criteria that leads to burnout and risk of suicide, et cetera, and the potential impact all of this has on patient care is this stigma associated with mental health issues. Physicians in particular are trained to be very resilient. They are resilient individuals typically, but they're also trained to be very strong and not admit to weakness. So there is a stigma associated, particularly if there's a sense that there may be an impact on potential licensure. Excuse me. So the recommendation is to ask about current mental and or physical health conditions that impact the ability to practice. And that is a manner of not asking questions that aren't directly relevant to the physician's ability to provide quality patient care, but instead very directly asking the question if there are any issues that would impact that ability. So in my current role, I would recommend the board's consideration of the Federation of State Medical Boards recommended language.
Everyone have a copy of that? Okay, yes. Just as a side note to that discussion, I can tell you that the American Osteopathic Foundation is in the process of developing a funded process specifically targeted at osteopathic medical students who are at risk of burnout or suicide, and are putting together all the bits and pieces to fund this type of project. So we at that organization are very much concerned about the health and well-being of our future physician population, and we're putting our money where our concerns are. And I don't know when it's going to happen and how much and things like that, but just so your organization knows that the House of Medicine is in need of helping itself stay healthy and well, so that it can serve those who are in need as well.
Great, thank you. I appreciate that. And also so that the board is aware. Did you have a question, Dr. Lally?
I'm all in favor of this, but I just have a question. What do we currently have on our application now? Sorry.
It's in the packet,
Question 23.
yes, it reads.
It's in there?
Do you have any condition which in any way impairs or limits your ability to practice medicine with reasonable skill and safety, including but not limited to any of the following? A condition which required admission to an inpatient psychiatric treatment facility. 2, alcohol or chemical substance dependency or addiction. 3, emotional, mental, or behavioral disorder. And other, please explain.
So the concern about that specific line of questioning is nationally. The concern is that there are people who may be at risk who are not willing to disclose specifics that this asks about, and it wants to leave it more open-ended, more like the Federation has designed, so that, well, that's a different question.
The medical board's application is also included in your packet, so you can compare what the medical board is asking. But my understanding is that the medical board is also working on a different language for their application.
Legislative process, I mean, what's
No.
the way of doing it legally?
No, it's just their application, and is your application referenced in regs?
It just, yes,
Yes.
just the
So
form
you would
number.
just be updating the form, the staff would. Medical board confirmed that they would reach out to us and let us know what they ended up coming up with for this particular question, because they are looking at their question at the
Yeah,
same time.
hopefully, because they're represented at the Federation as well, they should have the same
Right,
language.
so they're willing to share all their work and
Good.
what they end up with.
So I have a quick
Thank you.
comment. So let's say we add this language and they said yes, and they give us their whole life story. How do we then keep them safe if they open up and share their thoughts and feelings with us?
I would say that's at the discretion of the licensing board.
And I think it's a case-by-case basis,
Right.
based on the facts and the information.
Right. At this time, we do ask for medical records that, pertaining to their impairment, if they disclose that there is one, and then we review it case by case.
Well, you mean discretion. If there's somebody really that could harm themselves and they let us know, then what is our plan of action?
Well, the question you're asking is if a applicant says, well, if I don't get my license, I'm going to kill myself, and has intent, then it's your responsibility to notify for their protection, if you have the information to notify.
Who do we notify?
Well, that's, I don't know what the regs say relative to notification in this situation.
There's
So
nothing in regs at this point.
Yeah, and whether there will be or not, because there needs to be a hold harmless, so that if you report, because you're not, I don't know that HIPAA applies to the organizations or not versus the medical institution. So that's a more complicated question that we're gonna have to look at to see, so that we don't become liable for trying to help someone. And I think that it's duty to report. And it's always an issue of, you have to report a problem. If the problem becomes apparent to you, it then just becomes a question of, well, who do you report it to? So in the process of making these changes, I think that's a question that CMA is going to have to answer as well, and we're going to have to talk together and say, what's our next step?
Absolutely.
Great question.
Do we know when the medical board, if they finalize their version of this question, when we would be able to see theirs?
Based on our discussion, I felt like they would be reaching out once they determined what that question was going to be, even if they hadn't already instituted it. So,
Can I ask a question of Kathleen? I'm assuming that CMA will have input from the medical board as well, so that there's cross discussion between the association and the board, so that there's the whole idea is that we're all sharing this information, so that if something comes our way that is of benefit to the work your community is doing, then we can forward it to you, and hopefully vice versa, so that if something comes from CMA to us, or not CMA, but from the medical board, we can pass it to CMA, because I don't know what the transparency is between those two groups.
Yes, absolutely.
Okay.
And this is all kind of a whole new world. The organization I'm building is brand new, developing it from the ground up. So it's evolving in what the interactions will be, et cetera. But yes, there is, I know California Medical Association does work closely with the Medical Board of California. So absolutely, I think the fact that I've got, the background with the osteopathic entities will be helpful in ensuring that communication continues to exist.
And then the hope is that, that the Federation will be involved in the process, because they're doing it nationally, and, we need statewide to get the national benefit
Right.
as well,
Absolutely.
from 70 different boards through. Anything else?
So how will this affect their application process in terms of, do we put a hold and do a 3-month waiting period till we figure it out and we can process their application? Because this is part of the intake, right? As they give us all the documents?
To give you a context, the process is this application goes through our processing, and then the executive director is the one that receives this and makes the decision about whether this person is fit to practice medicine. So that is all with the executive director. So that's one thing. It's not public. But the public part is that when we receive public documents.
He can't hear you.
Okay.
Maybe go to
Can you go to Mike? Thank you.
That's really important.
Can you repeat the question and repeat the answer?
Yeah, so the question is, as the applicants submit their information, and there's something of concern, what do we do in terms of time frame for their application process? Do we put a hold on it, or do we move forward if there's something of concern?
There's no hold. This goes directly, it's identified, all of the questions, whether it's some of the other questions in addition to this would all be identified by the executive director, and it would be with the executive director that makes that decision. There's no other public part, except the second part of the public part would be for Public Records Act requests. Applications, I believe, are subject to that. And so one of the things that this does is balance sort of the privacy aspect of not having people check a box, but there would be a yes. And so I think you're achieving at least some privacy, but you're not totally keeping this out of the public realm. I just wanted to make that clear. But the decision, there's no hold. It gets processed. Decision is made by the executive.
And I think this is an evolving concept and an evolving process that we continue to refine as all these groups are working on this from a multifaceted perspective.
Yeah, and I might mention that the board should consider my new organization, which incidentally is yet to be named, so that's why I haven't been specific about it. But consider us as a resource if you are made aware of physicians who are potentially in distress. We have resources that can support that.
Thanks.
Thank you very much for the opportunity.
Okay, thank you for coming, and hope you make your meeting in time. Thank you for allowing me to go off schedule. Now we'll go back to the cures. There was a couple things about cures. There have been some problems within the system, some functional problems within the system relative to, and I've had this previously myself, in terms of physicians having to change their passcode, and it has to occur every 90 days. But in the process of doing that, there are security questions, and what happened on mine is the security questions all changed. I mean, it was like they weren't even my questions. So there's been some software glitches in there, and so what happens is there's a number of people who have to call the helpline to try to sort this problem out. So Dr. Lally had talked to me that there had been some server problems relative that he experienced recently too. So I know there's some glitches going on, and hopefully, I mean, the interesting things is, I mean, Cures has been sort of in a testing phase, and it continues to be tested because I think the statute has a specific date yet to come forward where everybody needs to be using it. So it's been sort of beta tested when Cures 1 came out and then Cures 2 came out.
Right.
So what's the new, or what's the date?
Okay, so the Cures was actually certified on April the 2nd, meaning that all the testing was done and it was good to go. Everybody should be able to use it and function correctly. So the effective date is October the 2nd. Everybody has to start using Cures before they prescribe medication for the first time, or every 4 months if you're going to keep the patient on the pain management regime. So I did include the statistics from the Cures 2.0. This is the August statistics, and I do show that we didn't really have too many calls into their help desk for osteopathic physicians. It looks like, which page is it? On page 4 of 5, it says the number of phone calls to the Cures help desk. For osteopathic physicians, there were 99 calls. But if you compare that with the number of times an osteopathic physician uses Cures, which is 54,486 in that 1 month, which shows that the DOs are using the Cures, and that's good news. And we have 6,116 DOs that are registered. So we are still, there's a few DOs that have not yet registered, and they should be. Cures just provided us with a list of all the doctors who have not yet registered. But it doesn't really give us the full detail of why they're not registered. Some of these doctors may not even have DEAs. Maybe they're doing nothing but OMT. They have no DEA number, therefore they do not need to register. So compared to the 7,000, whatever I said earlier, in the number of practicing physicians in the state of California, we had 7,696. Of those, 6,616 are registered. So I think we're doing well. We're doing okay. But we still need to reach out to some of the doctors who are not registered.
One of the national concerns regarding the Cures is that each of the states have their own Cures, and they're not talking to each other. So the problem here is we have people who go to Nevada, or people who go to Oregon, or people go to Arizona, they go to other states, they procure medications, and yet we are not aware of it occurring in our state. And I don't know what the process is going on right now relative to trying to have crosstalk so that when you look up John Doe, you'll see that John Doe received medication in California, New York, Colorado. I mean, people who travel can take advantage of the system. So I think that that's something we'll kind of keep our eyes on right now because I think just an in-state cures isn't enough to protect patients.
Right. Yeah, and these are certainly concerns that we can bring up to the next cures, at the next cures meeting that we continuously have with them, so.
Yeah, and if also just if I can, some food for thought. Do we know how financially fit the company that runs Cures is in terms of how they're operating, and if they're in any jeopardy of maybe overextending themselves and going out of business? That's one question. And then also, I know there's things available like escrow for source code. So if they were to disappear, does DCA have the ability to have an escrow account where they can take ownership of that source code and all the data?
The Cures is actually ran by Department of Justice. So the
Department of Justice.
DCA does not have any involvement with their database. It's the DOJ is actually the one that runs it.
Internally.
Yes.
So
I'm sure that they had an outside entity that actually built the program for them, but they are the ones that have taken over and now in control of the.
So
Cures.
DOJ is federal but has state jurisdictions?
The Department of Justice this one is the State of California
State.
Department of Justice.
Oh, not the federal, okay.
I do know that they are doing extensive testing. They have been the past several months. They are going to implement a new, like the Breeze system has this Cognos. It's an IBM Cognos SQL. It's a way of going in and looking at the data more specifically and running, your own kind of scripts and finding stuff out. So they're adding this to Cures as well, but they've been doing a lot of testing on Cures, running reports and all kinds of things. So I think maybe that's maybe what's going on in terms of some of the glitches that you've been having in terms of your experience. But I know that's been going on. That they expect that new Cognos to come up on. I would say a couple months. I went in and got some testing on it. I will be, the board will be getting using the Cognos as well with Cures, so that will enable us to, for instance, go in and look at specifically, for instance, if we have a doctor who's, has a disciplinary order and is restricted, on Schedule 2 and 3s. Then I could run it in Cognos to see if he specifically has scheduled written those prescriptions during the time he's not supposed to. So it gives us a little more, power or oversight in terms of how we can run and look at the data. So there'll be other, things that we can do with that.
And the minutes will reflect the Cures numbers that you gave us as well?
Yes.
Good, okay. Anything more for your Cures report?
No.
And just one last question. Are we then tasked with making sure that the rest of the DO sign up and looking into those numbers from the Department of Justice, or how are we being held accountable? So
Well-
can we say, well, we know 100 don't even have a
Right.
license to prescribe
Right. Well-
ones, or do we just eyeball it?
No, we did an update. We updated our website for additional information on Cures. We have the frequently asked questions and everything on Cures. And we did also do an email blast to all the doctors who currently have an email account with us, email address on file with the board. We did send out information. We did send out a brochure and also the frequently asked questions about that. We will run the report that Cures provided us, and we'll cross-reference to see if these doctors are in fact active physicians in California, and we'll reach out to them when time allows. It's very time-consuming to do this, but we will reach out to them and make sure that they are aware that they should be registered, even if they're not using it. If they have a DEA number in California, they still have to register in Cures,
And what
whether they prescribe or not.
And what happens if they don't?
there's no recourse per se, but we do have it in our cite and find. So if they get picked up for any other discipline, we could also use that as a part that you're not following the instructions and therefore you could get cited and fined.
Got it. Thank you.
Thank you, Angie.
You're welcome.
Next, coming from Sacramento, California, we have Corey Sparks, who's going to be presenting the enforcement report and discipline. Take it away.
Thank you, Dr. Zumuto. Thank you, board members. It's a pleasure being here. And I don't think there's anything really significant in the report. I do want to note that because we did have one of our staff members resign in early June, that did affect our intake with complaints coming in. And so you will see on here that there was in our intake section, a lot of cases started to our pending cases started to increase. And that was because of there was a backlog of us getting these cases into the system. So
And we're back up to full steam now?
we are getting there. I think we're back up to almost full steam. The new analyst is quite amazing. She's very quick. She's picking up really very quickly. So I think we'll be doing very well in the next month or two. So. Okay, let's get started. So the following OMBC enforcement report covers 12-month period, started from July 1st, 2017 to June 30th, 2018, basically the fiscal year of 2017-18. The OMBC enforcement report is divided into 5 sections: intake, investigations, enforcement, performance measures, and probation. The data is reproduced from the BREEZE enforcement reports. So that big data table, that's all of our intake. As you can see, we have complaints received, we have convictions and arrests, and then on the bottom tier of that data table, we have the total intake. Data table one above, under total intake, OMBC received 564 complaints. 16 of these cases were convictions and arrests. During this period, 569 cases were referred to desk investigations. The aging for intake measures the period from the date that the complaint was received, date stamped, to the date the complaint was entered into the system and referred to investigations or assigned. So I want to make that very clear. So in the intake process, when you see the word assigned, it doesn't mean it was assigned to an analyst. It just means it came in, we received it, and we put it into the system. So I want to be clear on that. So the average number of days to assign a case was 33. And in figure 1.2 below, we see an increase in pending cases from March to May 2018, and then a spike in assigned cases in June. This was the result of a backlog. So what this means is basically you see that red line just jot up like that. That means that's when we finally started inputting these cases into the system. So once the staff individual resigned, a lot of these cases were sitting in, and then we finally were able to put them into the system, and that's why we had that really big jump in assignment. Page 2, in figure 1.3 below, the bar graph illustrates the monthly average number of days for the intake process, the date received to the date referred to investigations. The performance target for intake is 30 days. The board did not meet the performance target in the second quarter of 2018 due to staff shortage, which caused the backlog. The overall average for the last 12 months was 33 days. So you can see it back there in April, May, and June. In June, it was like 62 days for some cases. The average was 62 days to enter in cases into our system, which is way above our performance. Investigations, desk investigations. For all desk investigations during this period, data table 2 above breaks down the monthly totals for how many complaints were assigned and completed. So this is where we actually assign it to an analyst. During this period, a total of 486 cases were assigned to an enforcement analyst and 537 were completed. The average number of days to complete a desk investigation was 93 days. In figure 2.2 below, the assigned and completed caseloads averaged around 45 cases per month until April, when the assigned cases dropped to 30. pending cases averaged around 150 and then decreased to 115 in June. So the reason why those pending cases started to drop is because we weren't assigning those cases from intake. There was a big lag in that. Okay, page 3. Field investigations. Data table 3 above breaks down the monthly totals for cases assigned to the Division of Investigations. Completed cases are either closed with insufficient evidence or referred to the Attorney General's office for disciplinary action. During this 12-month period, 27 cases were assigned to field investigations, 34 were completed, 29 cases were pending at the end of June 2018. The case complexity is the breakdown of the specific allegations that are currently under investigation. So this pie chart at the below breaks down what specifically investigators are investigating, and this is all current right now. So this wasn't during the period. This is right now.
Can I ask a question, Corey?
Yeah.
We see that the significant amount is 46% under prescriptions. And do we know the type of prescriptions? I mean, are these all opioids? Are these all scheduled drugs
They're
that?
scheduled, yeah, they're scheduled. Everything that would be usually an opioid. Basically, what happens when we get a complaint on excessive prescribing, the first thing that we do is we'll run a cures report on the physician, and we send that to our medical consultant, the wonderful Dr. James Lawley, and he will review that cures to see if he sees any anomalies or excessive prescribing or mixing of drugs of any of that nature. And if he does see that, then he'll point out maybe 8 to 10 patients. And then what we'll do, when I get that back, I'll run a PAR on each one of those patients as well to see whether or not they are doctor shopping
Right.
or whatever. And then all that goes to an investigations.
Because what I'd like to use this data is to see where, I mean, obviously you've got the bad actors.
Yeah.
So you deal with the bad actors in the way we've been treating the bad actors. But then there's the doctors who might need education.
Right.
And so even though there's not necessarily, let's say we're not going to discipline them, maybe what we need to do is notify them, and maybe we make, this is something for thought in terms of where do we need to educate doctors about doing a better job? Because they're not to the point where they need discipline, but they're not to the point of doing a good enough job.
Right. Well, you're looking at it from a proactive approach where we want to get the doctors informed about,
Yeah, I mean, I don't want to use the data and wait till they become a problem.
Right.
We want to intercede to help them be better doctors.
Right.
And the question for us to continue to work on, of course, is how to take the data and be proactive to prevent a problem before it happens. Because the bad actors are always the bad actors, and you got to deal with them in a different way.
Well, first of all, the mandate of the board is to protect the public. So most of our money and funds right now at this point are put on the issue of discipline, finding the bad actors who've hurt people or are in the process of hurting people and going after them. That's kind of where, in terms of our mandate is being proactive in terms of helping the physicians. I don't know how we would
Well, here's how
allocate our resources. to do that.
here's how we do it.
Yeah.
We get the data.
Right.
And we notify the physician community, the medical associations, and say, look, we've got 46% of the physician population of complaints are related to this. I think you guys need to spend time on re-educating
Sure.
doctors on topic A, B, and C. So it's not that I'm not necessarily saying that we as an organization do the educating,
Right.
but we make a process where the people who do the educating know what they need to educate about.
Right.
So I'm just saying transfer the data to the people who can hit the largest audience and make a difference.
Right.
Or, quick question. When you dismiss a claim and we don't find anything out of the world and cures, what do we tell the physicians? Do we alert them that there was something submitted but nothing got found? Or do they ever find out there was something submitted?
Oh, in terms of complaint, yeah,
Yeah.
they're notified. Usually, I mean, there's two processes. Basically, if it's a complaint that's not as serious, I mean, that it's just a desk investigation, they're always notified of a complaint, and they're given an opportunity to respond to that accusation. And the job of the desk analyst is to write up what those accusations are and to provide that information to the physician. We also get all the medical records possible for the medical consultant to review. So that it's due process. Basically, there's an accusation against the doctor. We get the medical records. We notify the doctor of what that accusation is. They respond to it. And then the medical consultant reviews that. Now, there are cases, usually maybe 1 to 5% of those cases, that we don't want the doctor to know about that we got this because it's so serious that we need to go in and do an investigation. We don't want to tip them off. We may need to do it undercover. But that's a very small percentage.
Yeah, because I'm thinking when we have the chance to reply, maybe we can refer them to somebody that could help them, or at least let them know that that exists.
Well, I think that's what the consultant does for us,
Okay.
is he makes those types of reservations.
And every time we do place a physician on probation for an overprescribing issue, we do require them to take a prescribing course, and that's part of their educational process.
Dr. Lally? Yeah, might as well.
Part of this is a little bit of a science. So Corey, who's actually got good eye for things, will get a complaint. He'll pull the cures. He'll look. And then if he gets a little flavor, and we're not just looking at excessive amounts of one thing, we're looking at combinations. We're looking at things that are potentially dangerous. He'll get that to me. I will go through it. You do a lot of math. I just try to figure out, if you're getting 1,800 Percocets in a month, that's probably a lot. And if there's no documentation anywhere for it, that's even more problematic. So we then give the doctor a chance to offer some explanation. And at that point, we have to call it if we call it. So it's all Schedule 2s, 3s, combinations of 3s. Like I have a little bit of a gut issue with someone getting Ativans, Ultram, Percocets, Norcos, and Ambiens. That doesn't really work, especially if it's a primary care physician. The pain specialist, interestingly enough, really, I don't think we've had anything about them except maybe someone didn't know how to do it. I think that's what it was. But I would say that we've been on top of this, and it's a little bit more. I don't like to get 770 pages of cures because a doctor has been busy. And we look over an extensive period of time. We don't just take a 1 month shot. Usually we do a year, 6 months to a year.
I try to run a 3-year.
Yeah.
But if they're
Too much.
If they're prescribing, 7,000 within a year, I mean, it will,
That's a lot.
The cures will only, after 10,000, the cures won't, it'll say you have to limit the time range, because after
You have to
10,000
refine
hits.
it, refine the search.
It won't run it, yeah.
But this came to your attention through a complaint. The reason you're looking into it in the first place, correct?
Right now it is. We don't really
Yeah,
have the
that's
manpower.
the only
Yeah.
reason we'll look in the cures if we have a
Right.
complaint on excessive prescription. That's.
But because I think that the legislature eventually wants us to be proactive and start going.
Well, that's the whole testing with the cures and Cognos, and they're trying to develop reports that will automatically pick up. They already have that in cures right now, so they have some ad hoc reports in there that do that pick up physicians who are, they have some thresholds in there that if they over that threshold, then the doctor comes up as a potential, excessive prescriber. So yeah, they are looking at those types of automatic detection systems within cures.
And then do we also look if it's pure negligence from an individual making the wrong choices, or if there's any outside influence from pharmaceutical companies pushing drugs?
Well,
know,
we
or
look at-
partnering with
when-
physicians?
When we look at a doctor, we just have jurisdiction over the doctor, and so when we look at them for excessive prescribing, we must have the medical records to look at to determine why they're prescribing, because there might be a legitimate reason for them to prescribe, a patient that amount of drugs. There could be end-of-life type of situation. But we don't know that until we look at all of the evidence. All that the cures does, and someone providing this allegation, is simply just a starting point to look at it. So we don't really know that until we do the full investigation.
Thanks, Corey. Why don't we get back on track and get through more
Okay,
data?
so right now, the complexity for all current field investigations, there are 18 excessive prescribing cases, 1 impairment case. The impairment case meant mentally ill. There's an allegation of a doctor being mentally ill. 1 sexual misconduct case, 1 criminal DA case, 4 fraud cases, 9 negligent cases, 1 unlicensed case, and 4 substance abuse cases. Okay, page 4, figure 3.3 below compares the aging of completed desk and field investigations per month. The aging is the average number of days to complete an investigation, starting from the complaint received date to the date the investigation is completed. Of the 537 desk investigations completed, the average number of days was 93, which is very good. It's about 6 months. Of the 34 field investigations completed, the average number of days was 480. Any questions on that? Okay, aging for desk and field investigation. So this matrix breaks it down within a specific time period. The data in data table 4 and figure 4.1, we see the aging matrix for the number of all investigations that were closed per month within a specific time period. 277 cases were completed within 90 days. 171 cases were completed within 91 to 180 days. 59 cases were completed between 6 months to a year. 22 cases were completed between 1 to 2 years. 11 cases were completed between 2 to 3 years. No cases were completed after 3 years. The majority of the investigations, or 83%, were completed within 6 months, and 94% were completed within a year. Enforcement actions. For all enforcement actions, data table 5 above breaks down the monthly totals for each disciplinary action. During this 12-month period, 35 cases were transmitted to the Attorney General's Office for disciplinary actions. 18 accusations and statement of issues were filed. 15 final disciplinary orders were filed, and 1 case was declined by the AG. 2 cases were closed without disciplinary action. 4 citations issued, and 6 suspension orders were filed. At the end of second quarter 2018, there were 29 AG cases pending. Final disciplinary orders aging, so that's kind of broken up on page 4 and page 5 and page 6. If you go to page 6, in data table 6, the previous page, in figure 6.1, we see the aging matrix of the 15 final disciplinary orders that were completed during this 12-month period. The chart shows the percentage of cases distributed within each aging period. Of the 15 final disciplinary orders, 2 cases were completed within 90 days. No cases were completed within 180 days. 3 cases were completed within 6 months to a year. 2 cases were completed within 1 to 2 years. 3 cases completed within 2 to 3 years. 2 cases completed within 3 to 4 years. And 3 cases completed over 4 years. Of the 15 disciplinary orders imposed, there were 4 probationary orders, 2 revocations, 2 surrenders, 6 reprimands, and 1 license denial. Going on to page 7, we can see our performance measures. These charts basically indicate within each section the intake, investigation, and our formal discipline. Our performance target is the red line. So in intake, up at the top, we can see the performance target was 30 days, and then we can see each month where we hit. That was kind of covered in intake. Performance measure 3, this is all investigations. These are all investigations except for cases that were sent to the AG's office. So the performance target is 360 days, and our overall performance was very well within the performance target for, that's the cumulative total or average for both desk and field investigation. And then at the bottom, we have our performance measure for disciplinary actions. These are all cases sent to the AG's office. Performance target is 540 days. I think that's a little low, but that's what it is. We didn't set that, DCA sets that. So you can see it's kind of, some cases make it, some cases don't. So when cases go to the AG, we really don't have any more control over the time period.
Is the AG just overloaded with cases?
That's, I don't know, that's for them to say. I
Okay.
don't know, I don't
I
know.
mean, I'm assuming,
Yeah.
because he has our cases, he's got all the
They've
cases.
got all the board's cases in
Yeah.
terms of, so. Pending cases exceeding performance targets. For all current pending cases exceeding the performance target, there are 22 desk investigation cases, 21 field investigation cases, and 12 attorney general cases. Basically, this means that these cases right now, as they stand, are exceeding our performance target. So we can see that in each one of these categories under desk investigation, the highest aging value we have for a pending desk investigation is 832 days. So there's a case out there right now that's been open for 832 days for the desk. So that's a long time. So, but I don't know what that is. That's probably one of my cases that
Does the statutes ever run out on it?
3 years. There's 3 years. So that would be 900 and something days. So field investigation. There is a case that's over 3 years and field investigation's working on it, and it's a case, I don't know, I've talked to them about it, and they've told me that they can continue working on it for some reason, that it's not, I don't remember their explanation, so. AG case, they have a case, one of their cases is 1,233 days, so. But they have, like, a lot of the cases that they have are over the performance, so. Probation, there are currently 41 probation cases, of which 9 cases are tolled. That means that a tolled probation case means that they're out of state, and so that it's kind of the probation is kind of in a halted, or it's in a kind of suspended mode. So the total cost recovery ordered is $375,635.34 as of September 25th. $207,000 has been paid, leaving a balance of $168,588. So that's where we're at with probation.
Corey, an excellent report as always.
Thank you, Dr. Zamudio.
I had a quick question.
Yes.
Yeah.
On page 1, on the conviction and arrests,
Page 1.
page 1,
Uh-huh.
on convictions and arrests, I'm just curious, how does the board become aware that a licensee has a conviction or arrest?
Oh,
Is
we
that
get-
self-reporting, or how does that, what's the
It's-
mechanism?
It's the, we get notifications from the Department of Justice when someone's arrested, and that goes into the system and it's identified they're a physician, registered with us. We
Okay.
get a notification through them that
So
this person's been arrested. So then what we do is we'll go request a certified copy of the arrest report.
So it captures any type of arrest?
Yeah, any arrest.
Yeah, all physicians are fingerprinted when they first apply for a license. So as long as they're in the system, we get subsequent arrest
How
notifications.
about board members who are not physicians?
If you're not-
No,
So we don't know.
we don't know.
Oh, behave yourselves, everyone. Anything else, Corey?
No, I think that's it. I think there's one outstanding ballot that I have out that.
Oh, a message about ballots.
Oh. Well, I'm just saying, but there's one more out that I put out. I don't think I have all the ballots. back
Okay.
yet.
What I would duly like to do is have everyone please get on track. We are all adults, and we need to get things done in a timely fashion so we don't hold up but
You're not
our
holding
people are
them.
doing.
As long as,
No, you're holding him up. I gotta have a stick out there, right? I mean, otherwise, why? You know, I actually get excited because it allows me to distract myself with something else to do. And first day I see, I usually get it done unless I'm traveling. I even did that when I was in active practice, working. I mean, because otherwise, I found I would just put it aside, and you forget at the last minute and you feel jammed.
right.
So hopefully, it becomes a priority. I mean, if we can do that, then everyone can do a better job. What I'm going to do at this time is have a 5-minute biologic recess so that everyone can groom up and look their best for the next portion. So
Okay.
5 minutes, we'll see you in a few.
Thank you.
I want to thank Corey for his fantastic presentation and his willingness to put all this data together for us. Okay, so number 7, our next section, regulation update and possible action. Want to come forward, Terry, and pick a microphone that's working for you?
Yep. I think it's tab 5, actually. Yes,
4?
tab 5.
Oh, tab 5. Tab 5. Yeah, I put my steering stick there. I knew I did something.
Ah. Okay, I would like to ask the board president if I could switch the order of the last 2.
You can do whatever you want.
Thank you. Okay, so first, these 4 regulations are up for your consideration. Some are related, some are not. The first one is the postgraduate training license. What is related is this is related to SB 798 and its implementation. And among the things,
Can you tell me what page you're on?
I am on, let's see, the SB 1690 postgraduate training. I don't know what page that is. It's after tab 5. The tab 5 is in the green. And then it has a purple page. So I am taking at least
I got
these
tab
first
green.
2. Huh?
Purple, right here. Okay,
Purple. So I
right
am,
after purple. Okay,
so I'm gonna take the first 2 in order. I'm just flipping
Got it.
the back
Okay.
2. Okay? So the first 2 are fees. The first one is the postgraduate training related to the implementation of SB 798. And I'm putting the fee forward, just as context, because part of the implementation for Breeze requires that we have our regs in place before they can implement it. So in backing up the whole implementation process, I have to put regs into place and promulgate that. Hopefully, they will be approved and ready to go by the end. The Breeze team on the IT end has committed that yes, Breeze will be up and going with this new license type as of January 1, 2020. The concern I have is this fee getting approved in time, so that it can be implemented into the Breeze. And so I'm only to expedite this process, because regulations have been taking as long as 2 years. So I think that was asked before. And so some of that can be complexity. So just having one single thing, the fee, I'm hoping for the best in terms of the expediting, that it will go through in a much faster manner and be timely for purpose of implementation. So.
can I ask one question? Since we're gonna talk about money and part of this,
Mhm.
is when was the last time this board increased their fee?
We got a fee increase. Go ahead, Angie.
We increased our fee in 1995, but that was only for A temporary increase for 2 renewal cycles. We went from 200 a year to 300 a year for 2 years, 2 renewal cycle, and then in 1999, we had to bring it back down to 400 every 2 years.
Because that's always the thing that the constituency is concerned about.
Right, how often? So we have not, right, Angie, increased the application fee.
The application fee's been $200 since 1995, yes.
Yeah, and this is the government's decision in our state, what they want us to do to make it happen. So
Yes.
if our constituency is concerned, talk to their local politicians.
Yes, yes. This was, as everybody recalls, a bill that Board opposed, but now we're in the implementation stage. So I'm bringing this to you because this is considered new workload, which is different than fees, like when we asked about what the history of the fees are. The history of fees that are currently in place are what they call for current workload. And there's sort of, for lack of a better term, a rule that allows the board to promulgate fees for new workload without respect to their reserve. And that is the idea that fees cover workload. If we were to raise the fees for the current workload, then one of the considerations is like, how are you spending your money, and what's the last time you raise the fees, and that'll be the next agenda item, that kind of conversation. But this one, to distinguish, is new workload. We're newly implementing it. There are costs to this implementing this new license, and so these fees, while they don't totally cover it, as you'll see, have some way into covering the cost. We will, kind of as a preview, be in the hole in terms of it'll cost more to implement than what we're going to be charging in fees, but I have listed what our considerations are. This is a board decision. I didn't put I proposed an amount, but I am leaving it up to you in terms of your final recommendation, if you want to change that amount, to do so. So,
Was any of the finances affected by knowing that we may get money in between 2019 and 2020, or is that just not even considered in case it doesn't happen?
Well, I think, as you recall from Mark's discussion of the budget, the structural deficit, we're spending more, obviously, each year. We do get money in, so that increases our reserves, but the trend is still we're spending more money than we bring in. So going to the rule about when can you raise fees is, I think from our kind of erosion of the structural deficit, the paying back of the reserve, we're probably looking at needing to raise fees around 2021 in that ballpark. Because that's when, with the structural deficit, we're going to start to go through even the reserves and get down to the less than a year in terms of reserves. So yes, to some degree it is accounting in that. As I listed in this, the fee revenue is for the application doesn't really cover the whole cost. So if you jump down to overall costs of implementing this training license are $350,000. If you go with the proposed $400 application fee, this would be non-refundable, and it would be for a 3-year license, so slightly longer than our current license. With an estimated 300 applicants per year, that would generate $120,000. Okay, so $120,000 obviously doesn't meet the $350,000 cost. So why, if you, in the discussion, I go into the math, is that if you were to charge a fee that would cover the $350 cost, that would be $1,000. So we're sort of saying that I'm guessing you're not going to be in favor of $1,000. So the balancing here of the amount, while it could be arbitrary, $400, what it is trying to do is get closer to cover the fee without having it be unreasonable.
What does the medical board charge for a license?
For their application fee, it would be $491, and their license is, I think, $780. For this one, they would charge a reduced fee for the license, which would bring it down to, I think, what's a little bit less than 400 for the license fee, plus the 491 for the application fee. So we are way lower than the medical board's fee, even at this modest $400 fee proposal.
I would think you would want to go up to like 500, but when they do the 490, it makes people feel like they're getting something out of it. So maybe like 495 or something, so people feel like we're not paying 500, so it's a good deal.
Just like the retail.
Yeah.
The nine.
Yeah.
So do you have a recommendation for us?
Well, the recommendation is 400, but I didn't put it, as you note, in the recommendation like I usually do, because I do want you to discuss what you think is fair. Because that's, the balancing is what's fair, both perception as well as this population, and knowing what the costs are.
Do you need a motion at this time?
We would if you are ready.
Is there a motion? Is there a motion?
I'll motion it.
Is there a second to the motion?
What do you motion? What's your motion?
We're motioning,
So
we
so
need
this
an
is setting,
approved
this is
proposed
setting the,
regulatory language for the training license fee, and we need to specify what that fee is.
so we have language before us, and you also have a fee to set. And so that number can be plugged in the language. You have your language in your packets. When it's time to approve the language, I have the special regulatory motion.
To really discuss it,
So
we
we
need
have
to have a
that.
motion to discuss it.
So we need, if you're gonna do an amount first and,
Yeah.
yeah.
Oh, to discuss.
Well, we got, I mean, so we have a motion to discuss. Do we have a second?
No, we don't need a motion to discuss.
We don't need a motion to discuss.
No.
Okay.
If you want to consider a potential fee for this license, then you can entertain a motion. We can discuss it a little further if there is discussion or public comment, and then we can have, we can then address the actual
So
correct
we've
language.
talked about $400 at this point, with the presumption that it's gonna need to be raised again in 2022, 2021?
Well, I think, okay, to give you context, the application fee is not the biggest generator of revenue. The fee type that we would probably be adding would probably be the renewal fees. Because the renewal fees, just as a rough ballpark, would generate, if we went up to, did we say, 600 or 800? We never looked
All right,
at
so
it.
right now, we're talking just about the training fee.
Yes, and so what we have for purpose of the deficit is the context of charging an application fee. The next agenda item is raising our current application fee to 400. And then later, we would have to get statutory approval through a bill to raise it, because the board's already approved raising the actual licensing fee to 800. So that, for you guys, has been settled. It's just that we haven't done anything in terms of the statute, because we were told we had to wait until our reserve was spent down, oddly enough.
Right.
So when we do that, raise the actual license fee, that will eliminate the structural deficit.
But are we talking about the license fee, the training license?
No, so this
Okay.
one is just the training
Right.
license, and because of a recent amendment by the medical board, we are unable to charge potentially a training license, or it is somewhat in doubt. In terms of the language, what we are able to do is to charge an application fee. So one of the things that went into
So
this
training
thinking is that
license,
the medical board does
Application.
a reduced fee for this whole idea of a training for the first time they get
what are they
licensed.
charging?
They charge $491, and then a reduce would be half, something like $300 or $400 for the actual license fee. So instead of the full, I don't know, $1,200 roughly, it would be more like a little under $800.
Well, it's my understanding that, and I don't know, this may be incorrect, but most of the residents have their medical license fees reimbursed to them by their program. So it's not a cost directly
Good to
to
know.
that person,
Good to know,
It's subsidized
in-
by their
by the
program.
UC or whatever residency training program, for the most part.
for the most part.
I don't know about specific individual programs.
So they're not in a kind of an
You're not-
income issue situation.
With regard to
With
licensing
the
fee.
application fee. Well, one of the things is that right now we're proposing an amount for the application fee, and we're doing it instead of, since and Sabina could possibly chime in, the language that authorizes us in this new version said application and processing fee. Arguably, we could say processing fee means licensing fee. But if we're wrong, it really screws up the implementation timeline. So to just front load the non-refundable application fee would assume we'd have a fee in place as soon as we can and implementation would be smooth. That was why we went with the non-refundable. But one of the things that we are not doing, which is also open for discussion, is we were not planning to charge an application fee for full licensure for anybody that has a training license. So in terms of being a good deal, you would have a one fee amount, no license fee amount, and no application fee amount for when they apply for full licensure. So we're not charging all the fees that we normally could charge.
But
So
they
they're
will
getting-
pay, but they will pay a licensing fee
Right,
upon completion of the 36 months.
got it. So they're getting a deal out of it.
It's a good,
Well,
I
that-
would think it's a good deal because it's also 3 years, not having to pay an application fee. We're following what the medical board's doing.
But as a deal, we would be taking $150,000 hit, right?
Correct.
Which we would try to make up for on the other licensees by increasing.
Yes, but that's something that you should consider very seriously, is if that's the way you want to go. I'm not recommending one way or another. It is really, your fiscal responsibility to balance. The general principle is fees should cover workload, okay? And we know from the estimate, it doesn't, but 1,000 may be too much. I don't know if you want to reconsider whether we charge an application fee for the full license as a way. But again, the application
why
fee
don't
is
we-
a small number.
Why don't we settle the issue first with the
Okay.
training license?
Yes,
For
So we
the,
can-
sorry, I'm sorry. For the non-refundable training application fee, if an applicant submits their application and for whatever reason there's a defect in it, do we give them the opportunity to make that correction or do they have to reapply? I'm just kind of
yeah, we
foreseeing
would,
a chance that
we
there could
want,
be.
the goal is for a full completed license, I
Right.
mean, application. So we would give them the opportunity. It wouldn't be denied, it would be sent back.
Okay.
So there's a
Yeah,
big
you
distinction.
need to document A, B, and C.
So
Okay.
if you don't meet the requirements because something's left out, it gets sent back. If you don't meet the requirements when it's fully filled out, that would be when you could be denied.
Understood,
Yeah.
okay,
Right,
You
so it would just
you lied on your application and forgot to tell us.
right,
it'd just
about
be
your-
termed deficient, and then they have an opportunity to cure.
Right.
gotcha.
So let's talk about money. So, we started with 400, we've heard 495 or 491? Or 5?
There's going to be a deficiency. I mean, if it were close to 500,
Still.
just using 500, that would be, you said 300 applicants. So
Yes.
150,000 out of 350. So now your deficit is 200,000
Right.
instead of 230,000. I'm wondering, one question is, would the initiation fee or implementation fee, pardon me, of this program change as Dr. Zamuda was pointing out that there may be increasing osteopathic medical schools here in California? Do we expect there to be soon more than 300 applicants per year? Or that's based on residency spots and that is not likely to change?
I think we built in that there would be an increase,
Okay.
maybe a 10% increase every
Okay.
year. I don't think we'll see, generally, when we see trends, our licensing goes up about 10%, our enforcement's going up, sometimes as high as 20%. But I don't see the residencies going up in the 20% range. If they went up, it could be 10%. There's definitely going to be an increase, and we built that in with the costs. But this is not one of those kind of expenditures that's going to vary a lot. Once it's implemented it's gonna run kind of the same way, it's maintained, we still have our same, sort of staffing costs, if you will. So this is really the estimate of, the front end of estimating what the cost would be. Now, one of the things that is true, that we don't know will be true in the future in terms of cost, is the implementation cost for Breeze was estimated to be $80,000. But DCA has said that that's not gonna be charged to us. It would be something that would be included, this whole implementation would be included in our regular overhead that we pay to them. If that changes, there could be future increases in overhead, which we can never predict, but we have to kind of anticipate. That would be an area that we might see a change. But that wouldn't be just because of the training license. But that would be a cost I could see increasing.
So remembering we're a public entity and we're a nonprofit organization, and our due diligence is to the state of California and our member physicians, and we have to make sure that we are charging enough to do proper business. So I've heard 500, and we've talked about the percentages of potential increase. We'll only know within the next 3 to 5 years, where numbers are really going. I don't necessarily anticipate an out-migration of training unless, with the increase of schools and things like that, the propensity is for
The increase.
increase, yeah.
Right.
Is there anyone who has a problem with the concepts we're talking about? I want to make sure we're on the same page.
I do have one question for Sabina. Because our statute, our ceiling for application right now is 400, but because this is a new license, can we go beyond that statute of 400 for
The statute
application?
doesn't have a ceiling for this.
Doesn't exist yet.
No, it does
Well, it-
exist.
Oh,
There's
does?
just no ceiling the way it was written.
Oh,
Yeah, the bill has already passed. It is law now, so we do have to move forward. But the language is shall charge a non-refundable application fee, application and processing fee. So they didn't set a price.
They don't give you a ceiling.
there you go.
Right. However, our application fee for physicians, regular physician application is set at 400.
They would have to call it out separately to set this, give us a ceiling, which they haven't.
Okay.
So since there's no ceiling, we should ask for more until we're told otherwise.
Well,
Dr. Lally.
Thanks. The only thing I would caution is that the trainees all train together now. There's the single pathway for GME accreditation and such, so you are gonna have DOs with MDs. Programs themselves are not gonna be really happy having to write a check that's a different amount of check for the DOs in their program versus the MDs in their program, and that could potentially hurt some people's chances of getting in a program. Not that they would be that silly, but,
So
these guys
are you
working on a
suggesting
budget.
then that we have the same fee as the MD counterpart would
I
have?
think if we're gonna make any changes, we make it on the practicing physician. I don't mean to get on my colleagues, but we should be the same across for MD/DO for their training, because they're trying to single pathway everything, and it'd just be less hassle.
And what is that fee, Terry?
It is $491 plus a half of 50% of the $790.
But that's the licensing fee at the end of the 36 months. They don't charge it up front.
So they're
They're only charging an application fee, same as us. Because it's the same statute. And it says that they can only charge a one-time application.
But they already have in their other section of the statute the ability to charge a reduced license fee.
Angie, talking to the mic, please.
I'm sorry. My understanding is that they are not charging the licensing fee up front. They're only going to be charging the application fee. And once they finish the 36 months, that's when that reduced licensing fee comes in place for them.
Yeah.
Right.
I-
Whereas we don't have a reduced licensing fee for residents. So once they finish their 36 months, they will be paying the same fee as any other full licensed physician, a DO physician.
Okay, so then in translating the numbers, then their application fee, if it's $491, would be what they are charging
Right.
the training.
491, does that include the fingerprint processing and all that? Or is
I
it
think it
491
does.
for the application?
I think, this is getting into detail that I don't have.
Yeah, I'm not sure.
Well, can I make a suggestion then? Can we basically adopt the same financial structure that the medical board has and get the correct language and numbers to
Fill
make
in
that happen?
later? That's a Sabina
I mean,
question.
since there's a question
Okay, let me
about
see.
the numbers.
Sabina, can somebody go on the medical board
Yeah, I'm-
website and look at that?
I was just pulling up the website, so,
Okay,
what, can you just, table this, a bit? And then I will see what I can find out on their website, if they have any pending language or fees.
Okay.
For their last meeting, perhaps, I don't know, did they
They
already?
had to approve it in their July meeting,
Okay.
I think.
All right.
the
I'll
end
check
of
it out.
July.
so why don't we have her look that up?
Okay,
Why don't we
move on to some of the other ones.
move on to the other ones, and we'll
Okay.
come back to this when we have more information.
Okay, next one, also a fee. The initial license fee, this reg is proposing to.
1690 section you're talking
It's a
about?
1690 section as
Okay.
well. And that's a section for all our fees. So I'm only, if you jumped ahead to the language, only changing the, if you flip the memos 2 pages, then and then after that is the language. I'm only changing in the language from 200, I'm crossing out to 400 under the physician surgeon original certificate application fee. So this one, like the similar or analogously to the training license, because it's an application, it doesn't generate that much income. But given the structural deficit, every little bit helps. And we have not changed this fee ever in terms of the license, the application fee. So and we have statutory authority as the board to make the change up to $400. After $400, we would have to go to the legislature and have a bill. But you have the ability to make the change to $400. So the proposal is to go ahead and raise it to $400. And in this particular memo, I pointed out what the fiscal situation is in terms of how fast we're eroding. The structural deficit is eroding each year our reserves. Okay, so the last structural deficit was 140,000. Current year, it's estimated to be 482,000. Next fiscal year, it's estimated to be 1,073,100,000, and the following year, 1.102 million. So as you can see, it really is the structural deficit is cutting into right now what are healthy resources, but they don't last forever, and it would be in the near future we would have to address that. So this one in again, because of the limited nature of the application fee, would generate a little bit. And so on the flip side, I'm talking about what it would generate in terms of, okay, I guess I do the history. At the bottom, on average, this would generate an additional 180,000 if we raised it from 200 to 400, because the population of just applicants is much lower than the entire population of licensed physicians.
So is everyone clear? We're talking about increasing the licensing fee from 200 to 400?
And to make that, in the discussion section of my memo, I highlight the history of the board increases. So, in 1995, we had 1,380 active in-state licensees, 344 active out-of-state, and 776 active, for a total of 2,501. And we charged 200, in terms of workload and expenditures, we're charging 200 for that. Now, looking forward, we've seen a 529% increase in the workload. So I think the increase in the workload would justify
Right.
increase.
Cost of doing business has gone up.
Yes, yes.
Any further questions or discussions? Is there a motion to approve regulatory language for the initial licensing fee increase from 200 to 400?
So that's gonna be a regulatory motion, so it's, I'm gonna
Oh,
go
there's
ahead.
special language?
Yes, I'll go ahead and then somebody can say so
Yes.
moved. Okay.
Okay, special regulatory language.
I move that we approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
So moved. Can I move it? No? I can move it. Okay, I moved it. You seconded it? All right. Can we call for the question? Where's our roll caller? Yes.
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 Thank you, ladies and gentlemen. Next
Okay.
topic.
And then the next one in your packet is citable offenses, but I wanted to skip to the disciplinary guidelines just in order, because of one of the sections in there. So disciplinary guidelines would be your last.
1663.
1663 would be your last, proposal, your last, packet. Okay, I included the disciplinary guidelines, and the only change, the language that you would be approving is on, if you look at the disciplinary guidelines that have our logo on it, that document, it would be on page 31, is the proposed language, and it's highlighted in yellow. The rest of it is the same language that, the disciplinary guidelines that you approved at the prior meeting.
So we're on page 31 of OMBC disciplinary guidelines of 2019.
Yes.
We're starting at the top of the page in yellow.
Yes, and this is the, if you recall the discussion about within the cite and fine last meeting, the 2054, the unlicensed practice of physicians and surgeons. Originally, we were just raising this in the context of adding it to our cite and fine, but then Kathleen Creason said, you know, it shouldn't be a cite and fine, you should put in the disciplinary guidelines, and then Dr. Buhari said, why can't we do both? And then it was tabled pending legal, and legal has indicated that you could do both. We could add it to both the disciplinary guidelines as well as the citation. So this is adding 2052, unlicensed practice by physicians and surgeon due to inactive, suspended, or delinquent and expired license to the disciplinary guidelines. Now, as a preview, and the reason I wanted this to go first is because the concern, I think there was a feeling expressed, I think by Kathleen, maybe Dr. Buhari's recommendation as well to do both, is that this is serious, so it should be in our disciplinary guidelines. So this motion is somewhat simple, and yes, this is what you talked about doing, and I've put it in language. Now, the discussion about, for the next agenda item, in citable of fine, is that sometimes, if you look at the words of what this applies, due to inactive, suspended, delinquent, or expired license, when somebody has a revoked license, we no longer have jurisdiction over them. So one of the good arguments for having it in both in the cite and fines as well as in the disciplinary guidelines is to have it in both places, as Dr. Buhari recommended, is because we wouldn't have jurisdiction in some cases.
Who does have jurisdiction? The district
Nope.
attorney?
District attorney.
Yes, that would be then into the crime,
What's a crime?
crime of practicing unlicensed, without a license. So then that usually, and then we would, in that context, it would come if the DA prosecuted and there was a conviction, then based on the conviction, we could bring this up. So this would be a motion or a proposal to add this language to our disciplinary guidelines
As written.
as written.
Is there any discussion about the materials as written?
I have a question, and maybe this goes to,
Micah?
yes. I have a question, and maybe this goes to the licensees on this board. The way I read it, it says that if there is an unlicensed physician or surgeon who's practicing due to inactive, suspended, delinquent, or expired license, then the minimum discipline would be 5 years probation. My question is there, do you foresee reasonable that there could be a chance that somebody could be practicing with an expired license and maybe it's just more due to carelessness? And therefore, I'm reserved because I'm thinking if somebody's practicing, and I agree they're being careless, but I don't know if I'd be comfortable having 5 years probation if we're in that gray area where they're practicing maybe 1 or 2 days after.
I can answer that. That's the reason why we want to put it in the cite and fine, so those could be cite and fine instead of this.
Gotcha.
Yeah,
So
so
we
this
have
is
the
more
option.
the severe, somebody who's maybe never been licensed, they don't even have credentials to be a physician, and they're doing this, then that would be a criminal offense. But this particular one, if we revoked somebody and they continue to practice, that's also criminal. If we have a suspended physician and they know better than to be practicing, then we could take this action and actually revoke their license.
But simply letting your license expire, I thought was considered professional misconduct by the board.
It is.
See,
That's why I'm not stating that it's not something that we should just overlook, but I don't know if I would say I'm comfortable giving them 5 years if it was expired and they went like a week or
Right.
Which
something.
is the board's discretion, that's part of the discussion.
Right.
but if your license expires, you stay home
But that's what I was asking, is it foreseeable or reasonable that could
until it's
happen?
renewed or until you get it taken care of.
Yeah, that extra hour a minute could put somebody at harm.
That's true. And that's why we could do a cite and fine as a kind of a warning, don't let this happen to you again.
Well, so one of the things I highlighted in my memo was the distinction of the risk to public safety between an untrained, unlicensed person that I think everybody agrees, particularly even in the public, that would be really scary and very high risk. Okay, for somebody that doesn't register for their, it doesn't get renewed on time, potentially because they don't complete their continuing medical education, that the requirement of the continuing medical education is the intention to stay competent. You can argue the effectiveness of CME, but the goal is that competency is continued, and if competency is continued, there is a built-in safety to protecting public safety. When that competency is not continued, i.e. you miss, your CMEs, that's probably the biggest reason for non-renewal or delinquency, is that there would be potentially a question of how competent are you to be practicing. So you may have maybe not as great a risk, but but still a risk to public safety. The other element is creating a deterrent to physicians not to be delinquent. That's another benefit of having this be a strong disciplinary action. I agree it doesn't have to be 5 years. That would be something the board does need to decide in this, is whether 5 years is too much. I picked 5 years because it was pretty much identical to the aiding and abetting unlicensed practice, which although isn't practicing without a license, it is aiding and abetting someone to practice without a license. So it could be considered similar, and that's an existing disciplinary guideline, or not. That is for you to decide whether 5 years is the amount, or any of these.
Well, I think the key thing, it's within the spectrum of disciplinary issues.
Yes.
It's not out in left field. It's
I wanted to
standard.
clarify Mr. Moreno's position, because my understanding of what he's saying is that he's concerned that if that situation happened, somebody, didn't have enough CME, they potentially thought they had a category 1 and it was category 2. Are they automatically going to have 5 years probation? And my understanding is it's not. It's
Correct.
up to the board. So this is
Right.
not automatic.
Right, this is a guideline.
This is a guideline,
Yeah.
and they could also be under cite and fine instead of
Right.
under a criminal.
And
Right.
so, and
Yeah.
the decision, if it was stipulated in an agreement, then the executive director would decide, make a proposal
Right.
on the number of years, which could be less, she has that discretion. And then if it ever went to hearing, an ALJ could also choose to have less than the 5 years. And then when the decision comes back to you, the board could non-adopt or adopt that. So there are many options to be less than 5 years in terms of the amount. I think, these are, one of the things that is true is these are guidelines. And the guidelines are not like statute that you have to follow them to the word, but they do give you, as decision makers on discipline, some range to think about. And to avoid being arbitrary and capricious, you can see sort of all of the types of violations and what you give. And generally 5 years is kind of the standard. We do have a couple that are less than 5 years, but mostly it's 5 years is the standard. And then all maximum would be revocation. We have that for all of the language just in case the board has, an egregious situation. And so you're not tied to the 5 years, but from an enforcement perspective and a decider perspective, having the most range of options gives you the ability on a case-by-case basis to really match the discipline with what you think is the severity or an egregiousness of the crime or lack thereof.
Any more questions for Terry? This is statutory?
So no, this is a
No,
regular.
this is regulated.
Oh, is there any specific regulatory language that we?
Well, you've
need?
already approved this language
Okay,
as a whole. This is just the one change she's bringing before, we're still
Okay.
on disciplinary guidelines, right?
Right.
The one change.
The one change.
Right, so that would just be incorporated in your previous,
does this require a vote then?
correct.
Yes,
Okay.
it does still in her language. Her special
Okay.
regulatory language. So
So,
the
Everyone understand what we're gonna be voting on? Okay. Can I
Okay, so
call
that-
for the question?
With the edit as proposed, and then we'll be moving this all through the regulatory process.
Okay,
Okay, so I'm gonna go ahead and read that motion, just in
Yes.
overabundance of caution. I move that we approve the proposed text for a 45-day public comment period and delegate to the EO the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
so moved. Is there a second?
Seconded.
Vote, please. Yes.
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 Thank you, everyone. Now,
okay, now, the site, and then just go back to the next,
cite and fine.
the cite and find citable offenses.
Disciplinary.
We also, if you look at the list, I have the 2-page memo followed by the proposed language of citable fines. And if you look through page 3 on the language, I have highlighted in yellow the only change that I'm making.
On the regulations?
Yes, on the regulations. And this one is initially the reason for this proposed change, and this is the only change because you approved this the last meeting.
What was the page again? I'm sorry.
It would be page 3 of the language, proposed language. So first, there's 2 pages of the memo, and then there's also, you start at page 1 on the proposed citable offenses, proposed language. Did you find the purple page? Tab? It's not in there?
This is, this is the guideline, disciplinary guideline?
No, it would
No.
be just before the disciplinary guideline.
Okay,
So for reference, I have the 2-page memo at the front, the actual proposed language, and then just for reference, so these numbers make sense, I have
Oh,
the same
citable?
reference
okay,
page.
page 3.
That lists the BMP code and health and safety codes and a description of them. And it's
Okay.
added, the health and safety is added to this. So this is adding, did you find it?
Yes,
Okay.
thank you.
This is adding a new deadline in cures. October 2nd, 2018 is the deadline for the requirement by the cures statute that physicians not just have to register, that deadline already passed, but they have to actually consult. And so I think, Claudia, you mentioned about what kind of enforcement. Well, we have in our citable section, a citable section that includes failure to register for cures. This one would add failure to consult cures. And that number is Health and Safety Code 11165.4. And that's the only change, but I do want to highlight that inherent in this, when you discussed last time, wondering if the 2052 that we just put into the guidelines, I had included it in the citable fines, and there was a question of whether we should remove it. So I have it not as new language in this. So you would also be approving, full disclosure, that we're keeping also B&P Code 2052 as a citable fine, as well as in the disciplinary guidelines. That make sense?
Yes.
Okay. That's the proposal, to add the cures requirement as a cite and fine. Okay. Okay, 491 includes fingerprints?
Correct, 491 for the postgraduate training license, and includes the $49 non-refundable fingerprint processing fee.
And then it doesn't charge a reduced fee?
This combined fee must be paid before the review of your application can begin.
And
Once
what's-
your application is complete, and that's on the other end that you were talking about.
So the combined fee includes what?
So the 491 includes the $49 non-refundable fingerprint processing fee.
Okay.
And then the initial license fee of $808 before a license can be issued.
That's for full license?
Right.
Okay, but that's not until full license application. So it's 491 minus 49,
So,
right?
yeah, they have a frequently asked questions on,
Although if it's the same,
on their
it's the
website.
same price, right, for the fingerprint licensing fee?
Yes.
Okay, so if they do 491, that would include, although in our regs, we say just the amount of the application, we haven't included that amount of the fingerprint because it could change. So wouldn't we want to subtract the $49 from the 491? Sabina? As a way to accurately put the amount in the reg? I know we're going out of order.
If they're,
Should be included.
We should include that,
That
whatever the
$49?
fingerprint fee is,
Uh-huh.
because it's a processing fee, it's part of the
Right.
application
Well,
process.
we do charge
It's a
it,
cost.
just that what we don't do is put it in the reg. Because if the $49 changes, it's
But
not
you
in
can,
reg.
you can put the language fingerprint fee or whatever,
Right,
non-refundable.
yeah, so should we put, I don't know, Sabina, should we put it in there? The 491? It is, you're right, it is a fee.
as a
If we're gonna
total,
charge it. Yeah,
Total
that's a total,
Includes.
it's because processing, I'm assuming, includes fingerprinting.
yes.
You're naming the fee,
Yeah.
application, and processing
You don't have to list a
fee.
dollar amount because it may change, as you said.
Right,
Right.
so you're gonna have the total amount that you're charging to
Okay.
process your application,
Okay, which would include the fingerprint.
which you don't have to call out, yeah, I don't think.
Yeah, you shouldn't
Um,
even have to say that. It's just part of the process.
And I have a message in the medical board right now, they're gonna get back to me, but
Okay.
I'm just looking at their,
Okay.
I'm just looking at their website.
So it could be 491 is the number. Okay, so going back to the citable offense and adding the cures consulting health and safety code section. Do we,
Do we need special language?
yes,
Special
The citable
language,
offenses
please.
regulation, correct?
Correct.
Absolutely, I just like to say this paragraph over and over again.
and it is amending our regulation, Title 16, 1659.31, the record.
Correct. I move that we approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
So moved.
Seconded.
It's been moved and seconded, and may we have the roll call for the vote?
Yes.
Yes?
Yes.
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 Thank you very much, ladies and gentlemen.
Okay,
So now we go back to,
So now we go back to the postgraduate training amount. Or do we need more time? Now here's just a tidbit. If we were looking at a statutory ceiling, and the statutory ceiling was somewhat less than adding the fingerprint, we probably would say, oh, we won't add the fingerprint to the reg language. But since we don't have a ceiling, we can match the amount that the medical board's doing that includes the fingerprint. So that wouldn't be an issue.
so we're gonna say 491. And then are we gonna include the 808? Do we need to put that in at all?
No, because then, that's the licensure.
So that, we
Right.
don't need to put that in.
We are only
Doing the
can do application and processing fee for this
491.
training license.
Right, but what is true is, okay, so when we get to the licensing amount, they will be not charging, we're not charging an application fee for the full licensure, and we'd be, for the first amount, charging a prorated. And similarly, or in contrast, the medical board would be just setting a 50% lower reduced fee of their 808 for the full licensure, for the first full round. So the person would, the medical student would do the 491 upfront for the training license, no application fee, and then when they apply, they're gonna be charged the 400 something, which is around the same as ours, because but ours is gonna be lower because it's a prorated, so it depends on the birth month, whether they're gonna be charged the full 400 upfront, or they'll have to wait a cycle before they're charged the 400. But it seems similar, so. So that, I never would have thought of that, Dr. Lally, so that was good.
Thank you.
A good detail.
The only concern I have is if we go over 400, is that the residents will be paying a higher application fee than a regular license fee. Because the regular license, the full license application right now is 200. We are raising it to 400 if this is approved, because that's what the ceiling is in statute right now.
But it's 3 years and not 2.
Correct.
Well, it's just an application fee. It's just the fee, so it doesn't even include a 2-year license for unrestricted license.
But, right.
Whereas the 400 that they pay up front for the PGY will include a 3-year license.
Right.
But just as a perspective to see just application fee, I don't know whether it would look good for a PGY application fee to be higher than a full unrestricted license application fee.
Paid for by the institution.
Referring back to Dr.
Yeah,
Bernardi's.
that doesn't come out of the pocket of the trainee, for the most part, in most programs in California.
Pass through usually gets reimbursed to GM, it's a direct cost.
And the employer can afford it.
So
Because
she's
it-
asking about the perception, so that doesn't concern, the perception of having one be more, okay.
Do you increase that amount as well?
Can we what?
Can you increase, oh, you can't go over?
We reached this that way.
Okay.
For which one, Cheryl?
The fee that Angie is speaking of.
Not without a change in our statute,
Okay.
because our statute right now has a ceiling of $400 for application.
Right now, you did approve raising and that was one of the reasons I put it together, is, in our discussions, there was the concern about having one, the application be for the full license, at only 200 and this one is at 400, yes, the 400 is a combo, but now you've approved promulgating the increase of the application fee to be 400.
Right.
So then it would sort of match.
It's the $91 difference.
Right, $91 difference. And they're getting 3 years out of it.
Since I'm not an osteopathic student, there was comments made that the programs that the students are in during their residency refund the students. Can you explain that to me a little bit more? And what's the spectrum of that and how many schools, and do we know more specifically?
That,
Well, I mean,
I don't
I know all the UCs do. It's a reimbursable fee.
Mine did.
Licensing is the
Most
DEA license and California state license is reimbursable, and I just looked up a couple of programs that have big names, and that's the same for their policies as well. So I can't guarantee you that there's not some small residency program that does not, or specifies that it does not, but for the most part, that's the practice.
Okay.
Usually it benefits the program if they
Yes.
have, from what I remember over a decade ago, that if they have a resident who has their own DEA, who has their own license, so that they can cover prescriptions and write those prescriptions, so you don't need everything co-signed by an attending. So it benefits them greatly, so they encourage that, and one way they do is those fees get reimbursed.
Thank you.
Good questions today, sharp
yeah,
minds.
I know, great discussion.
I mean, the room is not very full, and it's good we have
But I'm
people
sure
staying
we have a
awake.
big webcast audience.
Hi, webcast.
Day for hearings.
So when our next board member comes back, we can
Do we,
do we need to take
do we
action
have
on
a
the?
quorum without Claudia? Yes, so you're fine to take action.
We're just gonna miss out on the fun. Does this require our special language again?
It does, so, and also we
Oh.
want to indicate if we're making our motion to set the fee at $491 also, when we do the
That we're
motion.
amending the proposed language, is that what we have to
Right.
say?
Yes.
Uh-huh.
So,
Yes.
the motion's going to include, I'm going to assume, or I'm going to propose, that when we do the motion, the fee will be updated and
To
what was in the
$491.
materials to $491 instead of $400.
Correct.
And then the motion would include that I move that we, or whoever decides to move this, that we approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
I so move.
Seconded.
It's been motioned and seconded, and now we're gonna call for the vote. Oh, yes.
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 Yes. Yes.
We got a lot done. Thank you, everyone.
Great.
Thank you, Terry.
Thank you. I'm gonna be very busy.
Mm. So, our next subject, we got done with 7. Number 8, discussion and possible action, legislation.
Legislative summary that you should have in your board packet basically are the bills that have been enrolled and either have been chaptered or enrolled. Enrolled is on governor's desk for signature. Chapter is that he's already signed it and it is now law. And these were some of the bills that we had discussed at some of the other board meetings, and so I decided to bring these to you to let you know which ones went forward and became law. There was one that we talked about, which was AB 1998, Safe Prescribing Protocol. If you recall, I think Dr. Buhari, you were very concerned about that one, and that was suspended, so it has not gone to the governor's for his signature this time around. And AB 2138, which was the bill that would not allow us to deny a license solely based on felony convictions. They did quite a few amendments to that. They changed the 5-year to a 7-year rule, and I do believe changed some of the language to more egregious offenses and so forth. And that has been enrolled, but at the last, when I checked yesterday, it had not been chaptered yet. So the governor had not signed that bill. It could have been signed today, but as of yesterday, it was not signed. So this is the reason why I brought these to you. If there's any one of these that you wanted to talk about, we can. SB 1480, the last one on there, which was chaptered on the 19th of September, was the cleanup bill for the sunset, and that's the bill where they did make several changes to the PGY licensing program. And they also changed the law that said the board has to meet a minimum of 3 years per year to instead requiring the board to only meet twice a year. And just for your information, AB 505, the very first one, when we brought it to your attention at the May meeting, it was a completely different bill. It had something to do with if the allegations that were brought to us had sexual misconduct or a felony conviction with patient harm, we could not stipulate to a settlement that it had to go to a hearing, but they gutted that entire bill and changed it to the current law, which is the testimony of the expert opinion, and that was chaptered on 9/18. And, oh, yes, another one of importance that we talked about was the Senator Hill's 1448, the probation status disclosure. That was chaptered. It has been signed into law. So any physician who is now on probation for I didn't print this here, but for certain types of probation, they do have to notify their patient that they are on probation. And the other one that was really amended was the physician and surgeon's opiate-dependent, is that the one? Yeah, the patient treatment management. We talked about educating physicians on prescribing. This was that additional CME that was going to be required of physicians to take. But what they did was they amended it and they changed it to, in lieu of the current one where they have to do 12 hours of pain management or end of life, they can do the 12 hours of continuing education course in the opiate-dependent patient treatment and management. So it kind of lacks at that a little bit. Any questions or any discussions on any of these?
Thank you, Angie. Next, I guess we're going to do the number 10, which is discussion regarding guidelines for the recommendation of cannabis for medical purpose update.
Right.
Is that the handout you gave us?
Yes, that handout was also given at the last meeting, and I do believe that the board members wanted a little bit more time to review it to see if they wanted to adopt this as their guideline, so we brought it back. And I did reach out to the executive officer at the Cannabis Bureau, and of course, they do not get involved with any recommendation for how a physician uses cannabis in their, recommendation, so forth. Their major role is more of the dispensaries and licensing the dispensaries and those that provide the medical or the cannabis.
guess my only concern, or not concern, but I think we should look at this closely, is in the page 3 where it says informed and shared decision-making. It says the physician should discuss the risk and benefits of the use of cannabis with the patients. There's not a lot of research or CMEs or any kind of training that we provide, from what I understand, Dio. So how do we expect them to really discuss the risks and benefits if they have no?
Well, I can tell you that there is some substantial reports regarding drug-drug interaction that have been substantiated. For instance, using Coumadin in regards to anticoagulation therapy has affected the metabolism of the blood thinner. And right now, it's highly recommended that patients who use a blood thinning agent, whether it's Coumadin or some of the new other artificial agents, that they avoid the drug-drug interaction with that. With the cannabis, yes. And there was one other product that showed there was some scientific evidence to show. So there is some things starting to pour in. However, not nearly what needs to be done. And I think that as the safeguards come out with effective researches that prove it, and it's not anecdotal, which means, oh, my patient got hives because he used it, isn't enough. I mean, you have to have substantial medical review and things like that that would allow physicians to give appropriate information. The other one is recommendations to avoid alcohol and marijuana combination if one were to drive. So if you were using medicinal marijuana and you knew you were going to be driving, that you should avoid the ingestion of alcohol products, even a minimal, because it amplifies its effects so that you don't become a risk to yourself or to others. So those are just two of the things that have come out. Now, relative to other things, if you're on chemotherapy, I don't know if the studies are out yet about that. So there will be things, but I think that there are some things that patients should be aware of and be cautious about. The other thing is, in using the product, making sure that patients understand that the metabolism of an ingested cannabis product is different than something that is vaporized or smoked, because of how the metabolism works, that the risk of toxicity and having a bad outcome from the product are much higher with ingested products if you're not careful. And that's well known within the community who sells it.
And although we do not have any requirements for physicians to take any continuing education on the cannabis, we're seeing more and more when the doctors are submitting their CME documentations to us that a lot of them are taking courses on cannabis prescribing or recommendation.
Do we have any changes to the guidelines, or what do we do with these guidelines today?
Discussion today, it's agendized just as a discussion, so there'll be no action.
I think that it's well thought out, well put together, and it is similar to what the Federation of State Medical Boards has come out with as well.
I think they adopted the recommendations, from what I recall, right?
Yeah,
Right.
they did, yes.
Yeah.
So this could be something on the agenda to take action next meeting. You're right, but this becomes a agenda item for the following meeting because we talked about it. And then at the next meeting agenda, we'll have for consideration for adoption.
I think there is a piece on telecommunication that maybe is not aligned with what we have on our records. Maybe we can look at that.
Do you remember what page it was on?
Page 3, second paragraph. Maybe we should look at that, what we have for our board, see if it's.
Oh, telehealth. The use of telehealth is compliance with BB Code Section 2290.5.
I think there's some language that we came up with like 2-3 years ago that says that we had more restrictions on telehealth. It would be great to maybe look at what we have for our language.
So we could put down that we review B&P code 2525.3 and 2290.5. So we should review that prior to taking any action on this at the next meeting. Okay? The other thing I would like to do is next meeting agenda to put Dr. Lally on the agenda for independent consultant report, if there is one. He has the opportunity to add to our knowledge. Let's see. And then we'll probably, pardon?
Standing report or just minutes?
Standing. And then hopefully, for the next meeting, we can have, when is the next meeting scheduled for? January. Okay, we'll put it on, although it may be done, if not done, as the follow-up report to the executive officer, executive director search. Either follow-up or results, something. Okay, what else? Is finance gonna be at that meeting? Did we need finance to come back?
We can always invite DCA or budgets to any meeting, so yes,
Okay.
if you'd like them to.
Can I ask a question about Patrick Lee?
Sure.
You guys know Patrick Lee? Okay, so he's Assistant Deputy Director. I guess my question is what kind of things would our board need to reach out to him for, or how can he help us?
Any concerns that you have that DCA can get involved with, he would be our contact person.
Would he be someone who should do or could do a presentation of some sort? I mean, will we benefit?
Sure,
From
we can
having
always
him
have a
talk to
DCA
us?
update, sure.
Yeah, so why don't we ask him to come for a DCA update? I mean, these people are there, I think we should learn more from them and become a better board because of it. And put Nicole Lee on the agenda too, so she'll come and talk to us about, yes? Pardon me? I can hear you real well. No, I'm just kidding. Yeah, I understand, but I think these are important things and, right. Yeah.
And then
Where will we be located? Sacramento again? Okay.
another.
Oh, yeah, do a nomination of officers.
Then can I include something? Do all the board members have the the updated version of the 5-year strategic plan that we put together? And is that ever going to be reviewed again to see how we're performing with their KPIs?
Do again in 2019. So next year, whoever is in at my desk will start the planning of the.
Should we at least take a look at how we perform or what we put together? Because there hasn't been any discussion from what I recall since we put that in place.
I think the only part of the past strategic plan that we fell a little short on was more outreach. But all the other strategic planning that we did we're on target with them, so yeah.
Anything else for the next agenda? And then we have to schedule the meeting, the telemeeting, minimum of 10 days away from now for, what are we doing again?
The-
executive officer duty
yeah,
statement,
yeah.
approval and any, whatever else.
Does Nicole need to be part of that call?
That would
Yes.
probably be very beneficial, yes.
Okay, so, how should we go ahead and coordinate those dates? Should we check with her availability, or?
She has informed me that somebody from her HR will be available, so we can set the date and she will she's accommodating.
Okay, and how much time do we anticipate that meeting to take? An hour
At the most.
at most? Are they, in HR, is the time of day critical for them?
As long as it's between 8 and 5.
Oh, it has to be between 8 and 5?
Yeah.
They don't get paid if it's before or after, okay. Is that Monday through Friday? Gotta ask. Anybody have any ideas? I'm always open. Is there any day better for anyone than others?
Is that for the full board or just the selection committee?
No, this is for
board.
the full
Okay.
board.
Yeah,
Fridays work better for me. I'll just throw that out there.
all right, why don't you send out the doodle, then we can mark our dates and try to match it up. Right, so send the doodle. Anything else we talked about the future dates. So what's the dates again for the January meeting?
The 17th.
Okay, after that? May 16th, after that? Should we doodle that one too? Okay,
Can I raise one issue you might think about? The January date is somewhat soon. I don't know if the new person be hired by January, but it may be, if you're gonna use the May 17th, or the January 17th date as a hire, that might be timely. But if for some reason it's not, the new person's not in place, the January date might be too soon.
he can't hear you.
She's saying that January date might be too soon if you don't have somebody on board for the EO. I would suggest keeping it on the calendar since you already have it on your calendars. And maybe use that as your
Yeah.
target with HR to make sure somebody's in place by then.
Which
But
brings-
just throwing it out there that if you have assuming you have a new person, maybe the end of December, that only gives that new person, do you wanna have that new person be setting up the meeting and business as usual the 17th? If they go beyond into January
Right.
for a new hire, then you have nobody in place by the
So,
January.
you know, sinkers.
I had to do I was hired in
Sink or swim.
December and had to do a January
Okay.
meeting.
Sink or
Okay,
swim.
so if it's not a concern, that's,
No leniency will be given the new hiree. So
We're gonna-
moved.
We have high expectations.
okay,
All
okay.
right. Speaking of high expectations, I'm looking for a volunteer. The volunteers are gonna get back to me soon, I hope. Who's gonna help me look for a new executive director?
Wait, do we need 3 in total? 2 in total?
Two, so it's not a public meeting. So, I'm easy to get along with, I'm efficient, I'll get us through it. And, even if you've never done it before, I'll make it easy.
Okay, if you make it easy.
And remember, it could be done telephonically,
It
so you
can
don't have to
all
travel.
be done telephonically.
Except for the interview, then
Yeah.
you'll have to
Come in person.
come in person, yes.
Yeah.
I can,
Are you volunteering?
I'll volunteer.
I only need, you two wanna do it alone?
No.
I just need one.
Oh, that's fine, that's fine.
I just need one.
I second the volunteer.
Okay, so Claudia,
Look easy though. We'll make it look easy.
this is her contact
Okay.
information. I need you to send it to her.
Okay.
Um,
I'm just gonna take a photo.
oh, take a photo, yeah, okay. Boy, that's exciting. We've got two people who are willing to look for an executive director. So how do you say thank you to Angie? Yeah, why don't we go around and, why don't we start with Machiko, or Machiko? You know her best. Isn't your first name because of Angie?
Thanks for my name. You're welcome. Right? Aw, I don't know, what am I thinking? I feel like this is Thanksgiving. Right? Like, go around the table, tell her what you think. What do you think before? I'm thankful for being your assistant and being able to learn from you. I mean, you have a lot of knowledge. 30 years? That's a lot.
Yes, it has, and thank you for being my right hand.
Thank you.
have done a lot for me, and I appreciate that.
Thank you. Your turn.
Well, I have to say, I really appreciate working with Angie. She's very easy to work with, and I don't feel she doesn't take my position lightly, or so I hear from her when it's important, not on every little thing, or 15, 20 times a day. And so, and she's very knowledgeable. So it's been nice, coming into a board new to this Practice Act. So it's been a smooth transition.
Well, the bar is definitely high for your replacement. I mean, extremely professional, very very easy to get information from, to get along with. I think she cares about her job and cares about the board and how the meetings go. And it'll be tough, but enjoy your retirement.
Thank you.
Yeah. I think my biggest takeaway when I first joined is our duty to protect the public. And Angie takes that very seriously, both on a personal and professional level. Also, as a board member, being the youngest when I joined and one of few females, I think like that was really good to have that kind of role model to kind of lead the way for us in the board and really show us that somebody can step up to that caliber and perform every single time. So thank you.
So I would say that you've gone beyond Don Kirpin's expectations. I remember when he suggested you to take over for him when he had to take time off for his health. He had faith, confidence, trust, and you've been all that he said you would be and could be. And, he was my mentor, and he influenced me a lot in a very positive way. And I think he's touched us all, very special way. But I'm grateful because, I felt that you've truly been a voice for the osteopathic profession in California. You've unfortunately had to get the bad with the good, but you stood strong, and you always remained professional. You've always fought the wind, so to speak, and I hope that you enjoy your time doing what you want to do on your schedule and get a fulfillment in the next stage of your life.
Okay, I'm not good at this because I don't like saying things like this, but you are really professional. I enjoyed learning from you, and it's good to see a woman in a position like this. You are the second woman that I've worked for in a high position. I worked for Assemblymember Mary Salas for 8 years. So this has been a joy and a learning experience for me. Thank you.
And I work for you, Cheryl. You don't work for me.
Work with you. How's that?
I echo everything that everyone has said. You are immensely professional, always prepared, on top of everything. When I first came in, I was not quite sure exactly what my full responsibilities were and what to do, and you have the answer to everything, and yeah, everything goes smoothly. I can't imagine you not being in that position, but I, as Dr. Zamudo said, hope that you get a lot of fulfillment out of the next stage and get to do what you want.
I think as the newest board member, when I came on and I expressed this to you, before how much I appreciated you welcoming me into this board and how welcomed you made me feel. And having served on different boards, I can definitely see, and it's a testament to your management, to your leadership, how well run this board is, and I think that speaks directly to you. I admire your management. You're always extremely cordial. Everyone is excited to see you. You greet everyone. I'm going to miss you. I miss having you around. I'm sad that this may be the last time, but I wish you well with everything else you have planned.
So when I was a medical student in the 80s, I used to be your guys'
Warm body.
warm body so they could do practical exams to get licensed and such. And I met Angie in, I think, 88. Does that sound right? 89? Yeah. And I had more hair. And, you know, she's been like a big sister to me because we were born on the same day. She's just much older. I have that backwards. So Angie's like family. She came to help us when Caitlin had her issue, and she's just been very, very, just a good person. So I've been thrilled. I was on the board one time through, did a whole cycle, and under Angie and Linda. I think it was Linda and Angie. And then I'm back now, and then with this current position, I'll outlast her. But it has to do with the age factor because she's a little older.
You won't let it go, huh?
No, actually, I'm the older one.
Yes, you are.
Right? We determined that. And our backgrounds are similar. We have mixed heritage. So, but she's just been wonderful. And as you've all seen, she's everything we said plus more. I mean, there's probably many, many more things we could say about her. Have we talked about her bitchy side at all? I just.
It's a good thing.
No,
Okay.
we're not
well,
gonna go there.
She does have that, but she's very professional about it. But she is firm. She is firm. So I'm gonna miss her for sure, but I have her cell number, so I'll keep in touch. Thank you.
So Terry and you guys want to come up to the mic?
Well, Angie is a good friend as well as my boss. And in a professional context, as you've all expressed, you know, having a sense of being relaxed through a friendship as well as being a really good team. The thing I miss, she's an animal lover, and she gives me a ton of advice on cats and dogs, which saved my pets. And as a team, you know, when we were arguing against SB 798, we're awesome together, and I'm definitely going to miss that. And in all the writing and the daily operations that we do, she's a perfect complement. She knows the details, she knows all of the history and the institutional memory, and then I just write it. So it works out really good, and I'm definitely going to miss you. I know I think it's good to retire in the sense that I know you'll enjoy your life, but I was always also rooting that she would stay. But I also know that she's going to enjoy her life more on the retirement. It's tough to do state service.
You have those bar graphs ready for Angie?
No bar graphs. I will say, though, that was part of the reason they hired me, Dr. Kirpin and Angie, because when I went into interview, I had brought this report in, and it was all that I had done previously, and all these bar graphs and charts, and Dr. Kirpin's like, you got to hire him. That's what we need, you know. So, but I took over Angie's job. So she taught me everything in terms of how enforcement works. And literally watching her in the office is quite amazing. It is quite amazing how much she knows and how smart she is. She, any individual that comes into her office and asks a question, 99 times out of 100 she has an answer for it. She knows what to do. She knows how to solve the problem, and she doesn't put up with a lot of stuff. However, there's been times when I thought, you know what, you really need to write this person up and get. But she handles the office very, very well. She handles, all of the procedures very, very well. I mean, she knows everything, and it is quite an amazing and so it is my kind of concern about the new person, because, you know, you go into Angie's office and she's signing, doing some work that's somebody else is supposed to be doing, and, and she gets it done. And so, but I will definitely miss her. I'll miss just the conversations, the debating, the talking about cases. A lot of times, some of these strange cases will come up, and we'll sit there and talk about it, and just kind of shake our head and just like, wow, you know, like. So, but definitely will miss her and her professionalism and expertise. So.
With that, meeting adjourned. I'm sorry? Yeah.